My judge is correct.
Ms. Rivers, are you ready?
Yes.
Great. Let's go on the record, please, in State versus Pritchett and Robinson. It is Tuesday, around, 9:15. We have our prosecutors. Mr. Robinson and his legal team are present, and Mr. Pritchett is here. A couple things just to knock them out quickly. Number one, regrettably, I have confirmed that the appellate courts of Georgia still view armed robbery as a capital offense, and it would be error for me to restrict closings to less than 2 hours. I will share with you all that it would be error by you to use 2 hours, but you can commit those errors and they wouldn't be a basis for appeal. So know that you have lots of time to share with the jury what you want to share with them. Second, I did some research on the question of lawyers in closing reading from transcripts of trial testimony. And it is allowed, but it is within the court's discretion. And there are even opinions that say, yes, while we've said it's okay, there's nothing wrong with the judge saying it's not okay. And because I have told the jurors several times that they will not get transcripts and that we don't have available for them any recordation of what the witnesses said, I think it would engender confusion, and we'd run the risk of jurors submitting a question during deliberations of, well, hey, could we have more of that video footage of juror testimony? And so my direction to you, Ms. Mignot, is to use your PowerPoint exactly as you have it, but don't press play on any of the embedded videos. You're free to share with the jury what you believe the testimony was and even have bullet points of that on the slide as you described it. But I am electing to exercise my discretion in the direction of we don't actually play it back, okay? Contrary to the Gwinnett judge's ruling, which is not an erroneous ruling either. I want to be clear, not in your defense, but in support of your creativity. There's a real old Supreme Court case, Brown versus State, here in Georgia from 1997, where a lawyer was reading from a transcript of trial testimony during closing argument, and that created a big fuss. The court said, you know, the court has the discretion to allow that because that's evidence. In the same way that if you wanted to play some of the Ring camera video, you could do that, the Ring camera video during your closing. And I suspect we're going to see some video of something during, that's why we have the special DA screen in here. I view that replaying evidence as being fundamentally different from meaning exhibits that were admitted, which the jurors can during their deliberations say, could we see the Ring camera video again? Could we watch Guns Up again? The answer is yes. The answer is no from me. Could we have a transcript of Officer Weems's testimony? No, you may not. And I don't want to create that confusion of, well, why are you saying no? Somehow Ms. Mignot was able to get us a recording of Latner's testimony or anyone else's. So I'm just explaining the basis for my ruling, but also encouraging you to continue to make that request, because my initial thought was that I'd find case law saying, of course, you cannot do that. And it's not. The case law is that it's the judge's discretion to manage what attorneys do and don't do during their closing arguments, with certain exceptions, you know, no golden rule, that kind of stuff.
Okay, so Your Honor, I just wanted to state that the court is going to give an instruction to the jury that lawyer statements or anything the lawyer shows you, present to you or try to, is not what you're to use to decide, you're supposed to decide this case based on the evidence.
No, that's not, I do give an instruction, but it's not that. I will tell the jurors again, as I told them at the beginning, that they are free to be persuaded by what you say, about what you say the evidence is, about conflicts that you observe in the evidence, that they are free to be persuaded. That's your job right now, and you're going to do it real well. But ultimately, they will be deciding if there's a dispute about what color the sneakers were. Were they yellow or were they green? It may be more Mr. Pritchett who does this, could spend a long time talking about how they're yellow. But the fact that he says they're yellow doesn't make them yellow. They'll decide. So I will say something along those lines, but it won't be ignore Ms. Mignot or you can't be persuaded by her. If you think she's right when she says a witness said that, you need to disregard it because only you decide that. That's not the tenor or the content of what I share with them.
Right, but I think the court statement that the jurors would ask for, can you replay, that the court in its discretion could say, if it didn't come from there, we're not sending it back with you, then you can't replay it. It's no different from them saying, hey, can I see Ms. Mignot's PowerPoint slide again? You would say to them, no, even if I had a PowerPoint slide, which was a photograph of one of the witnesses on the stand. So I'm asking the court to consider that in the totality of the circumstance in terms of you being able to say to them, no, you cannot request that again.
Okay.
Just like you would be able to tell them, you can't request her PowerPoint slide. You cannot request her to replay something for you, or you cannot request a transcript of any statements because the court has already said that.
Okay.
So I would ask the court to reconsider its decision as it pertains to us being able to play, especially a small portion. Maybe we could show it to the court and see.
No, I had in mind, because you didn't say, and that was wise, you didn't say, yeah, and I've got 30 minutes of Riley's testimony and 9 hours of, it was snippets. So I was thinking about that as I was looking at this case law and pondering what I felt was the appropriate way to manage it. So I appreciate it. And it may be, if I'm fortunate enough to preside over a case you try a year from now, I will have evolved into the progressive Gwinnett approach. But for now, I am the regressive. They've heard the testimony, and that testimony won't be replayed through your PowerPoint or anyone else's. It may be presented to them through closing arguments, which you're free to do, but it won't be the actual press play and they see Latner's mouth moving and the words coming out. I'm not quite ready for that, and I think it's not so much what I'm ready for. I think it's inconsistent with the concept and instructions that I've provided, that the jurors are to rely on their recollection, and there is not a way for them to have the witness testimony back when that's not a transcript of what was said, and there won't be a transcript, and we all agree with that, but it would be another medium through which they could have sort of in a violation of continuing witness. And I guess part of my ruling is infused with that notion of the continuing witness. It's not going back with the jury, to your point. They wouldn't say, could we play that slide again, meaning the content embedded in the slide. But I think it is of a family with the continuing witness. You wouldn't send a transcript of, if you had generated a transcript of the Kallish interview as part of the pretrial work you did, you wouldn't be able to send that back. And you know that, and you might try, but you would say, I get it. That's a fair ruling, Judge. And to me, this is of that family. No, it's not going back, but it is singling out certain parts of testimony and actually replaying it as if Sharon Latner's was in court again. And of course, she doesn't, during your closing, you don't get to say, wait, I want to just bring this witness in and say, hey, repeat that answer you gave. I understand why you want to do it, and you understand why I'm saying, let's use the slides, just don't press play on any of the slides.
So we would ask that the state not be allowed to replay any video footage based on that court's mindset and rationale and analysis, that they can put up a still shot of it, they can put up a picture of it, but they cannot replay any of the video because it would be tantamount to the same continuing witnesses rule, just like how we couldn't recall a witness. Replaying the video without any content would have the same effect. And we're asking that the state not be permitted to replay any of the video footage.
Okay, you're gonna go 0 for 2 on this one, because the case law is very clear that videos, not a video recording of a statement, like a recording of an interrogation, but surveillance video, or if someone was at the scene and on her cell phone, there was a fight and that person recorded it, that the jury can review ad infinitum, and it's not a violation of continuing witness rule. And I don't think the same concerns apply should any of the 3 parties to this litigation want to, during their closing, replay ring camera video. We don't have a ton of video, but the video that's been admitted, or the 2 music videos, et cetera, that is different fundamentally and conceptually from witness testimony. And that's the line I'm drawing, is that it's the replaying witness testimony, to me, is like handing the transcript during your closing. Hey, I just want you to have this transcript during my closing. This is what the person said. And it's not prohibited, but it's also not error for the court to exercise its discretion to say, the witnesses have testified, the lawyers are going to share, and Mr. Pritchett are going to share with the jurors what they say the witnesses said, and ultimately the jurors will be the arbiters of how that plays out. So you've made your record and preserved that. Those were the 2 rulings, other than we need to talk a little bit about the jury charge that had been left hanging, I think, from yesterday. Mr. Hiles, let me start with you, and I'll work my way around. Other than the jury charge, anything else from the state?
I got some of the case law you asked me. I emailed it to the court and to defense this morning as to the firearm.
Yeah, you sent Grant versus State, which was sort of like one of those gang cases that the appellate, for all that says is you don't have to have the firearm in an armed robbery. Well, if that's not what I was asking about.
But no, the last portion of it, he also, the very last argument that was made was that he should also not be convicted of the possession of a firearm during the commission of an armed robbery. And they said the last point they make is Grant also argues that without the armed robbery conviction, his gun possession conviction must be reversed, given our determination that there was sufficient evidence to support Grant's armed robbery conviction. This argument lacks merit. So,
but that's not the question I asked, because I think the armed robbery charges properly go to the jury. My question was about the gun. I understand you are reading into Section 2 of the Court of Appeals opinion more than it says. But you have other you lifted up a big stack.
That was the main case that I was citing.
Okay.
What I want to say is, in that case, only one person said that there was a gun.
The victim didn't, right?
The victim didn't, and the case was for possession of a firearm during commission of the felony. That was based on one victim that was not, that said, or an eyewitness that wasn't a victim that said they saw a gun.
Yeah.
Here you have 7 people that say they saw a gun, that say that they were in fear of being shot would they not cooperate. So just like any other charge, I think the circumstances around it are fair for that to go to the jury, that a reasonable juror could make the conclusion if they decided that was a firearm.
I agree with you. I wasn't trying to make folks engage in a thought experiment. I just hadn't bumped into it because mostly we try murders. And there sometimes is an armed robbery in connection with the murder, but there's always been a gun that was fired. And so there's not a good faith argument on the other side to say, how do we know that was a real gun? Well, how about the hole in the guy's head? And here, there are all sorts of reasons to be arguing replica, both about the music videos and this situation. And I think that lawyers can continue to make that argument, and that would be a question about the strength of the state's case and reasonable doubt, but not a directed verdict situation. Because I think there is the argument I think that was most persuasive to me, and it's circumstantial, but it's why would you bring a toy gun to a home invasion in Georgia in this day and age? Poor choice. But you could also say poor choice to do a home invasion in the first place. I'm letting counts 19 and 20 go to the jury. And someday I may even find a case. Grant is not inconsistent with the decision I'm making. I just wished in section 2, it put a little more meat on it, saying, hey, as long as someone thinks there was a gun, that supports the rest of it.
I wish they did too.
I know. Okay.
And yes, so the other case law I had already addressed, and I'll sit down.
Okay. Ms. Mignot, other than the jury charge, which we'll talk about in a second, anything we need to take up this morning before we bring the jurors in?
As to counts, I think it was 19, Your Honor. I think directed verdict. I looked at case law all of last night too, and I saw the Grant case, and I realized that we have a peculiar situation here. We've never placed a weapon in the hands of either defendant in this case. So the issue you have is, if you're charging somebody with possession of something, isn't it true that the state has to prove that they possessed a weapon? I think directed verdict is warranted on 19. I understand why the court would be afraid to kick it out, because if the court kicks out 19, then
it's not a fear factor. Trust me. I had no reluctance saying 17 is out. I don't mind directing verdicts. It makes life simpler for everyone. And most of all, I'll follow the law. And I don't shrink from having to do that, but keep going.
So 19 says you're in possession of something. The state has failed to meet what it stated in the indictment, that Mr. Robinson possessed any type of weapon. I can understand Grant is saying, hey, if it was a gun that didn't work, there are cases out there where the person saying, well, the gun didn't work. And the Supreme Court said, hey, even if the weapon doesn't work or not, you had a weapon.
Yep.
We don't have those facts in this case. So that is the concern that I have as it pertains to the court's ruling as to count 19, because you have to possess it in order to use it.
Yep.
And the state has not met that burden to show that it was even possessed.
Okay.
In this case.
I hear you. You are a very persuasive advocate. I fear you've persuaded yourself too much, because I'm going to sound like a broken record, but I have found that through circumstantial evidence and the kind of iron vice that I find your client and Mr. Pritchett in, where we have two accomplices who, if believed, put your clients at the scene, not in the building, but at the scene before and after, with masks and with things that were taken from that household. And so there is ample evidence that the two home invaders had what looked like firearms, both of them. The testimony is both guys had guns. Now it differs, like, was it a long gun, a short gun? Did it have a wooden stock? There are inconsistencies about the nature of the gun, but there was ample evidence that both of the home invaders had guns. If the jury finds that the home invaders are Robinson and Pritchett, the gun piece flows naturally from that. The part that didn't flow naturally, this was my hang up, but I've gotten past it, was, but were they really guns? And does that need to be proven? I don't think it was proven in the way that we typically see that it was a really gun, because a shot was fired. That's the kind of most, or the gun gets seized. The two easiest ways to prove that it was a real gun is someone is shot with it, or at least a bullet is discharged, or the Mercedes gets pulled over on its way back to Voss Coleman's place and two actual Dracos are taken from the car. We don't have any of that. And so I was wrestling with what if they were the props from the videos and they were sitting around Voss's place? Like, we can't go in there empty handed. They're just going to laugh at our masks. We have to go in with a baseball bat or a, hey, let's take this. And that's an argument you're not going to make it because you're going to say my client wasn't there. But I've already ruled that there is enough evidence in the record for the home invasion, armed robbery, and aggravated assaults, plus one ag battery to go to the jury, because I think there is the state has made a sufficient circumstantial case that there is not another reasonable hypothesis other than your clients as to who would have, wearing similar clothes with masks, gone into that house, done what they did, and then suddenly your clients pop into the car with Riley and Kallish. Assuming the jury believes Riley and Kallish, they may not. But because I've made that finding, I'm denying your either renewed or slightly altered, but still I understand it, request for a directed verdict on count 19, because I think the evidence is sufficient for the jury to consider whether the two home invaders possessed firearms. This is sort of an all or nothing verdict. I don't see there being a guilty on some and not guilty on others, because the state has shown there was a home invasion and these people were robbed and they had guns pointed at them. To me, the question, you guys are going to structure it how you do, is who did it? That's it. It's not what happened. There are inconsistencies about tall or short or stocky or not stocky, monkey mask, not a monkey mask, but I don't think the jurors are going to spend more than 10 seconds saying, was there a home invasion and did stuff get taken? Where they're going to struggle is, do we believe these women who don't seem to be being very seriously prosecuted and everything's getting lumped on these two guys? No digital evidence, no forensic evidence. It's all the things you're going to argue. But that's, I'm maybe misreading it, but the way I've been looking at this is it's a whodunit, not what happened. Not it was self-defense, it was accident. There was some confusion about it. It's these bad things happened. These guys had nothing to do with it. That's the defense. And the prosecution is these bad things happened. Really almost could be stipulated and the trial could have been a whole lot shorter. But these aren't the people who were involved.
And just for clarity, and I'm not asking this question just as gamesmanship. I actually do want to know. It's my understanding that if the state in its indictment say that my client committed a home invasion, is the burden on the state only to prove that a home invasion occurred, or is the burden to prove what they listed in the indictment, that my client committed a home invasion?
Oh, well, so I don't want to, I'm not the one arguing it to the jury. But of course, your client could be a party to a crime. He could have been, it's not the facts, but hey, I'm going to drive you guys there. The car will be running. I'm going to be there in the driver's seat. And when you come running out, Kallish and Pritchett with the drugs inside the white jacket, I'm going to speed us away. You know, from party to a crime or co-conspirator, your client could be liable for the home invasion despite never having set foot in the house. But that's clearly not the state's theory of the case. So the state has to prove a home invasion, and they need to prove that your client was somehow involved in it. The only evidence I've heard from the state in their argument is not he was a driver or a planner and that's it. It's he was one of the two with masks. That's what they've signed up for in their opening. But that's not what the law requires. You could be a party to a crime and have aided and abetted in some other way. But you know that. I mean, I don't think you're engaging in gamesmanship, and I don't mean to be giving you criminal 101 because you criminal 909. But I'm not limiting the state in any way as to how they choose to prove it up. I was merely giving you, from having sat through 7 days of trial, the evidence sure seems to be shaping up as a home invasion occurred. The question is, was your client involved in it in any way? Because if he wasn't, then the state has proven that a home invasion occurred, and it's a not guilty on every single count because Tyrone Robinson had nothing to do with it. But if the jury finds that he committed the crime directly or in some other way aided or abetted in the commission of the crime, that's black letter law. I mean, then he is liable. Did they prove that beyond a reasonable doubt? TBD. But as I've been processing each of these counts for directed verdict or not, the part of the elements of home invasion, the elements of armed robbery, the elements of aggravated assault have all been met. I believe the state has gets those to the jury. The hard part for the state is, well, who did it? And you're free to argue it differently, that, I don't think there was a home invasion, and that these guys were all lying, and they hit themselves on the head or they were so drunk they bumped into a wall. You decide whether that's a credible argument. It seems like the argument is these bad things happen, and Riley planned it, and Kallish was there, and that's what we know. And there's nothing about my client, no phone, no all the things that you've been saying. I have found in my ruling on the motion for directed verdict that I don't know how compelling it is. That's for the jury to decide, but the state has presented enough that connects Mr. Robinson and Mr. Pritchett to having participated in those crimes, that the jury may consider them in their deliberations. I'm not pulling it from the jury. Did I better explain myself?
I think I understand now where the court's position is. That,
Okay.
that even if the state is unable to prove who's done it, the court is inclined to send it to the jury if they can prove something happened. Something happened.
So again, I'm not finding that the state has proven anything beyond a reasonable doubt, but I am finding, now I'm repeating myself from yesterday, that there is more than no evidence that Mr. Robinson and Mr. Pritchett were the two guys who went in the house. It's circumstantial in part, but there are conflicts in that evidence. But the test, as I understand it, and frankly, as how you enunciated it in your opening to your motion for directed verdict, is if there are no conflicts of the evidence and the record demands a verdict of acquittal, I must do that. And when you and I were verbally sparring a little bit, it was my pushback that I think there is evidence, whether it's compelling or not, is for you to argue and the jury to decide, but there is evidence, circumstantial in part, that puts Tyrone Robinson and Maxx Pritchett in the shoes of the people who did the home invasion, meaning the two guys who walked in. And so because I think there is some, not none, then the jury ought to deliberate and consider those, because my finding was that it would not be an irrational verdict if the jurors came back with a guilty verdict on the counts that I'm sending to them. I just don't know what they're going to do. I don't think it would be an irrational verdict if they said not guilty, which is what we've got a jury for.
Understood.
Okay.
Thank you, Judge. I appreciate the time.
You bet. Mr. Pritchett, I am going to get to you, but I want to go over the jury charge. So let me share my screen, and then you can give me an update on your guy from Maryland. I'll be right back. The OneDrive isn't working. I gotta send it to us.
Need some protein?
I think so. Water ain't working.
That's fine. You transfer it to both.
Yes. Keep it.
All right, on your screens is the revised jury charge. And if you look on the top of page 4, I added a sentence to credibility of witnesses based on a submission from Mr. Hiles. It's actually an important one for the defense, and I appreciate him catching it. In telling the jurors what they can consider in assessing credibility, I've added that sentence about considering a motive for testifying, including pending prosecution or grants of immunity. Mr. Hiles, any objection to the addition of the sentence well, it's a distillation of what you submitted. Any objection to that?
No, I mean, it's not something I exactly wanted, but I thought it was necessary.
I think it's wise to put it in. Ms. Mignot, any objection?
No, Your Honor.
Okay. Is that screen not working?
Yeah, I was lost.
Okay, well, I'm gonna get you as unlost as I can. We'll see if we can get it to work. Is it turning on? Okay, in a happy way, or is it doing that? We won't know for a minute.
Icon is probably.
Is it a good icon or a bad icon?
It's a good icon. I think yeah, just come hit the export, but.
Oh, but it means like getting the keyboard over there? There's a mouse. Hey, did Mr. Williams end up showing up? How you doing, Mr. Williams? You're gonna tell me what your plan is about hiring counsel or working with Ms. Feely. Mr. Who? Okay. Is that someone you've actually hired or you're in discussions with him?
He was gonna come, but he said that he couldn't come because y'all had trial, and he has trial also.
Okay, so the excuse would be that he has trial, not that we've got trial, because here you are, and here I am, and we're talking. Tell me if Mr. Melnick had been able to make it today, and I said to him, hey, do you know Mr. Williams, and have you and he talked about the financial arrangements? What do you think he would say?
I got the phone, so
Okay, no, we don't need to bug him. So if we, pardon me? You know what, Mr. Melnick will, I'm sure, let me know. If we put this case back on our next trial calendar, any reason to think you wouldn't have brought him on board by then? Okay, then I think that's what we'll do. Ms. Nix, any objection to that?
Next trial calendar is in May 16th or May 30th?
I'm gonna talk with Ms. Nelson, probably for your sanity, we'd do the May 30th one. Plus that gives Mr. Melnick a little more time to get up to speed. Although these are not complicated cases, but you get him discovery, et cetera. So I've got the May 30th draft to review, and we'll just pop, I think it's 2 cases.
Yes.
Yeah, so we'll pop them both on there. Ms. Feely, you remain, or will it be Ms. Rios?
Will be Ms. Rios, but I'm happy to send the discovery to Mr. Melnick.
Okay, but until Mr. Melnick files an entry of appearance, and that's what Ms. Nelson will do today, is shoot an email to him saying, if you're on board, we need that entry of appearance, then Ms. Rios is gonna need to stay plugged in, and we'll add this to that May 30th trial calendar. Okay, all right. Any questions, Mr. Williams? All right, so your mission is to get Mr. Melnick to file that entry of appearance. All right, see ya. How's that monitor working?
The team's icon is on.
Okay,
I just turned it.
yeah, because we're gonna press on and I will ask Ms. Nelson to have IT come on down. So, do you, Mr. Pritchett, have any objection to me telling the jury about the fact that they should consider motives that some of the witnesses may have had to testify to include pending prosecutions or grants of immunity? Okay, great. The other change, if you look at what's on the screen now, the other involved parties, this used to say something about prosecuting the principal or whatnot. And Mr. Heil submitted some language that still didn't fit. So I wrote this. I'd ask you all to read it, and we'll start with the state and move on down the line with your thoughts.
I have no objection.
I would object.
Okay, tell me your objection.
I would prefer the language the court had previously.
Okay, the language I had before from the pattern was to me inapplicable because it referred to the fact that someone who didn't directly participate was being prosecuted and someone who directly participated wasn't being prosecuted. Shouldn't be something that confuses the jury, but those aren't the facts that that's not the structure that we got. The state's thrust of the case is direct participants, not they were planners or aiders or abettors. And so that charge didn't fit.
There is evidence in this case regarding that, and in fact, some of the questions we got from the jurors was regarding that.
It was regarding why is Voss Coleman not being prosecuted.
That's why I preferred the previous format that the court had.
Okay. All right, Mr. Pritchett, I don't know how good your eyesight is. Are you able to read what's on the screen there?
We're at,
There's that highlighted thing that says other involved parties. And so it's just that one paragraph below it. That's the only thing new on that page. I can read it out loud if you can't see it. I apologize for this setup, but IT woes beset us again. All right. Do you have any objection to that language?
I'm gonna adopt what
Ms. Mignot said? Okay. I'm gonna leave it in as is. I think it is more properly tailored to the process that the posture that we're in now. So what that leaves is.
I just want to take exception on the record regarding that.
Yes, ma'am. Whoops. What that leaves is what we're going to do with Mr. Pritchett, because that will affect the one highlighted section on the screen that remains in the jury charge. So, Mr. Pritchett, when we left yesterday, you shared that there were maybe some witnesses that you might have testify, and you explained you weren't 100% sure if they'd show up. Any sense of whether Mr. Abdullah showed up?
I got back to the jail at 9:30, so I couldn't only make one phone call. So it did abrupt all my plans to get him here. So actually, I did not think he was going to show up.
Okay. Do you have any other witnesses that you plan to call?
Due to the lack of preparation, I don't.
Okay. When you and I had the important conversation about your right to testify and your right to remain silent, your initial answer was, do I have to answer now? And I said, yes. And then your answer was, I don't plan to testify. But because we had to end at that point anyway, I told you I would revisit it this morning. So I need to know, you still understand, and I found that you did understand your rights to testify and not testify and the consequences of both those. I'll tell the jury not to consider it in any way against you if you remain silent. If you do testify, you got to answer all the legally proper questions from the other lawyers in this case. Do you maintain your decision to not testify?
Yes, I'm gonna maintain it.
Okay, then what we'll do in a moment, and I'll give Mr. Hiles a chance to move equipment around if he needs to, is we'll bring the jurors in. And when they're in here, I will turn to you and refer to you as the accused and ask you if you're going to present any evidence, and you can respond any way you want. The typical answer, if you're not going to, would be I rest, but you can explain it however you want. But you're telling me that the impact of what you're going to say is the equivalent of I rest because you're not calling any witnesses to include yourself. Is that correct? Okay. Ms. Mignot, did you have a chance to speak with Mr. Pritchett about the order of closing arguments?
I did not know.
Okay. Mr. Hiles, do you need to set up the equipment for part one of your closing, or that's only part two?
It's only part two.
Okay. Why don't you get your PowerPoint ready to go?
Can you please send me that language you just edited with other parties so I can update the PowerPoint that we're about to show to include it? Because it's not exactly how you just changed it. I want it to be on point.
You're talking about
The other parties?
other involved parties, the thing to which Ms. Mignot and Mr. Pritchett are accepting.
Yes.
Yeah, I'll send it to you.
Just to avoid any
You know,
objections.
the screen will be doing the first, leaving the wall portion, the first part.
Okay.
Yana, can you copy us on this?
Sure.
You've already emailed this draft to us?
I didn't because I did it this morning. So I'm going to send it to you as well.
Yes, Your Honor. Thank you.
And I will get a final version of the jury charge printed out so you guys have a hard copy for when I give that. All right. So are you, other than getting that language, are you ready to go, Ms. Green?
Yeah, just need to put that in. As soon as I get it, put it in, I'm ready.
Okay, it's been sent.
Okay. Thank you. Got it.
Good morning. It's the usual. Third time this trial. Wonder we're not on the record right now. If we, for our next trial, put that over there, so some jurors could see here, and then I also could see what's on the big screen. I just go into other courtrooms, I'm jealous because the judge isn't behind these screens and can't see. So,
Most of it's in law.
yeah, they gotta fix the I'm making a list to get IT.
Do you want any suggestions from the state in, well, Ms. Feely left, but
I do. In fact, I'm probably dragging you in for one of the sessions so that you can just bring stuff and say, look, and because I tell them there's lag, like, we don't see the lag, but you're good at creating lag.
it's the, I mean, the lag's always there with Zoom, but it's,
But just the fact that you couldn't play that big file, like it kept kicking you out of Zoom, that's not your fault. This needs to work. And so I don't.
DeKalb County's got some new equipment that's it's like tailored to.
So the problem is they can't say, hey, McBurney, you get this. There are 20 of us. And so it's 20 times whatever we do. And so this is what we've got, and they need to make it work better.
Bureaucracy as far as.
Okay. All right, you're back, Ms. Green. Okay, now we don't have Ms. Rivers. Okay. I will work on a verdict form. I got one from Ms. Mignot's team, but I'll circulate verdict forms for you all to review.
Hey, I'm just, while we're in waiting.
Sure. What kind it is?
Yes, to see if we have it back there.
Okay.
Very well have it. Okay.
Thank you. Let me know when you're ready. All right, we're back on the record. Let's bring the jurors in, please. Oh, Ms. Mignot, did you two speak about who's doing first closing? If you'll just huddle up and.
I'll be first.
Okay, thank you.
All right, for the jurors.
Thank you, Deputy Gordon. Everyone else can be seated. Good morning, ladies and gentlemen. Good to see you all. Last day of April, and when we left off on the second to last day of April, the state had rested. Ms. Mignot, on behalf of Mr. Robinson, had rested, which led to things we needed to discuss this morning. I'm going to turn to the accused and ask if you plan on presenting any evidence, sir.
No, just due to the lack of preparation, and failure to be disclosed of all the discovery. Not much.
Okay, so you're resting?
Yes.
All right. So the accused has elected to rest as well. Much like Mr. Robinson through counsel, the accused has no burden of proof, and so he's not required to present any evidence, although he had the right to do so, and he's explained his situation. So the evidence is now closed, and we are left with two more steps before you begin your deliberations. Closing arguments, which will start in just a moment, and then the charge, the law that I will give you that you must apply to the evidence as you find it to be. I told you yesterday, because the state has the burden of proof, they go first and last. I think Ms. Green, in just a moment, is going to talk to you more so about the law that she believes I'll be instructing you on, and she doesn't have to guess. One of the things we talked about yesterday after you went home was the law that I'll be giving you all. When she sits down with part one, having completed part one of the state's summation, then by agreement, Ms. Mignot will present for one time, and one time only, on behalf of Mr. Robinson. And then if the accused wishes to give a summation or closing argument, he'll be given that opportunity. After which, as I understand it, Mr. Hiles will get up for what we call the rebuttal, or part two of the state's closing. Important for you to remember that nothing the lawyers say to you during their closings and nothing that the accused says to you during his closing is evidence. This is all an effort to persuade you, and that's a very appropriate thing for the lawyers to do. And you may find if a lawyer says, you remember witness X said this, you're right, that's what witness X said. But in the end, you all decide what the evidence is. And so you should feel free to be persuaded by the lawyers, but if a lawyer says, by golly, that witness said X and your recollection is different, of course, you're deciding what witnesses said, what was proven and what wasn't. But this is an important opportunity for the state to urge you to find the defendants guilty, for Ms. Mignot and the accused, should he choose to point out inconsistencies in testimony, gaps in the evidence, et cetera, and to urge you to find the two defendants not guilty. When they're done with their urgings, I'll give you the law that you must apply to the case. Ms. Green.
Thank you, Judge. Share real quick. gangs, greed, guns, and lust. Now that the state's evidence is closed, you have more context to that statement. I want to thank you for being here for over a week, being patient, listening to the testimony. And now I'm gonna go through, like the judge said, some of the law portions. It is your duty now, it's on you, to be fair and impartial, to honestly seek the truth, to not seek doubt, but use your basic common sense and seek the truth. Follow the law as the judge will charge you, and a duty to deliberate. Everyone has to participate when you go to deliberate, and you are to report if no one does, if someone refuses to deliberate. You are to consider the evidence that was presented, the exhibits, the testimony, and the photos. Now, this is everything inside the circle is a visual of what you should consider when deliberating. Everything outside of the circle is what you should not consider. You shouldn't consider your passion, any public opinions, your opinions of the police, if you don't like the police, public feeling, sentiment, sympathy for the defendant. That is not something to consider when deliberation. If you disagree with the law, you have to follow the law as the court instructs you. Any conjecture, any prejudice that you may have, and any penalty or punishment, that's not your job. You are here for one reason, to give guilt or not guilty. Come back with the verdict. The penalty and punishment is something that's handled later. But inside the circle, you can consider the statements, everybody's statements. Expert testimony, you heard from our gang expert. Testimony of the witnesses, Lauren, Riley, the 7 victims you heard from. Photos, documents, the videos. The text communications afterwards, that's evidence. Any motive to lie, that's credibility, you can assess that. The observation of the weapons that you saw. The elements of the crime, and use your common sense. The presumption of innocence is something that the defendant has when he enters trial. He is covered with it. That's how the trial starts. But that presumption leaves once the state has provided sufficient evidence to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. And we've done that. That presumption is gone. Burden of proof. The burden rests upon the state. You heard that in opening, I'm saying it again. It's all on us. We presented the case of the state, and we are required to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. There is no burden for the defendants. There is no burden whatsoever. It never shifts to the defendant and to introduce or prove their innocence. It's on us to prove our case. However, beyond a reasonable doubt is not a mathematical certainty. It's not beyond all doubt. You don't have to have every single question answered, but when you step back and you look at the big picture, do you still have doubt? A doubt of a fair-minded, impartial juror honestly seeking the truth. It's based on common sense and reason. It's not vague or arbitrary. It is a doubt which you can give a reason to based on the evidence that you heard, maybe the lack of evidence, or the conflict in evidence. You should be able to articulate it, not you just feel it. So maybe some of you guys drove throughout the week from your neighborhood to the courthouse. And you have become accustomed to our downtown traffic, 9 a.m., 5 p.m. And you probably had to stop at one of these places. How did you know to stop? Because it goes from the F down to the E. And if you're like me, unfortunately, wait till the light comes on. But you pull up to the gas pump, you put your card in, you hear the click in your card, it approves. You are allowed to pull the handle, push your grade, put the handle in the car, and then you pull the leverage. You feel it, you can hear the gas going through the piping into your car, you can smell it, and then you see the numbers going, right? You don't see gas go in your car, but you have used an inference. You have used your common sense. You're seeing the numbers going up, you know it's gonna get charged. You are filling up your car. You hang it up after it clicks, you put it back into the rest, and you get in the car and you turn your car on. And what happens? It goes from E to F. And now you feel comfortable driving the car for a couple of more days, depending on which kind of car you got, a week or two, because you know your car is full. That is an example of circumstantial evidence. That is common sense. Not everything is going to be direct. And you can use circumstantial evidence. So let's talk about direct and circumstantial evidence. The law assigns no greater weight to direct evidence or circumstantial evidence. Evidence is evidence. Now, direct evidence are things that you can see, you can hear, you can directly sense, such as smell, taste, touch. It is evidence that points immediately to the issue in question. It may be brought into court in the form of exhibits, testimony, direct testimony of witnesses. So the sounds of yelling when they enter the home, or video footage of two armed males entering the home, directly saw that. Head injuries, you saw that in photos. Pools of blood on the floor, that was seen. Eyewitness statements, you assess their credibility, but they saw it, and you get to assess the truthfulness of that. Circumstantial evidence would be a proof of facts or circumstances by using direct evidence, from which you may infer other related or connected facts. They are reasonable and justified in light of your experience. What's some circumstantial evidence we had in this case? Observations after the home invasion. You got two men in the car. You heard from Kallish and Riley who those two men were, Robinson and Pritchett, and they threw out phones and wallets out of the window. You heard from 7 victims who said those items were taken from them. You're connecting the two. Asking for money afterwards. The messages of the girls asking for money afterwards. You can make an inference from that. Leaving the door unlocked. That's important because you heard from the 7 victims, well, not all of them, but most of them said that we kept the door locked, we shut the door, we watched the door. But what happened when Riley ran out the door? It was not locked, it was not shut. Here's another one, you rarely see this in Atlanta, right? But let's say you wake up this morning and this is what the city looks like. And you didn't see it snow, but you can reasonably conclude that it must have snowed last night. There's snow on the ground. Credibility. You, the jurors, must determine the credibility or the believability of witnesses in this case. In deciding this, you can consider all the evidence and testimony that this case includes. The witness's manner of testimony, their means and opportunity knowing the facts in which they are testifying about, the nature of the facts that they're testifying about, the probability or improbability of their testimony, their interest or lack of interest in the outcome of this case, their personal credibility as you observe it. You've been living in life, you've been talking to people, you've been assessing character all your life, credibility all your life. Keep it going when you go back there to deliberate. What makes sense? Party to a crime, I'm sorry. A person is a party to a crime only if that person directly commits the crime, intentionally helps the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. This is a good example from movies. We all see bank heists, bank robberies in movies. If you have 4 men that drive to a bank to commit a bank robbery, one is the driver. He never gets out the car. Another is the lookout. He gets out the car, but he doesn't go in the bank. He just stands outside. Then there's the man with the gun that goes into the bank and attacks the guard. Then there's the man without a gun inside the bank. Let's say he's collecting the money. He's working the safe. Who is going to be charged with armed robbery? All of them. They're all participating in together. And the man who attacked the guard with the gun is, under the law, it was as if they all had the gun and attacked the person. They are all charged with the acts of each other. The existence of a conspiracy may be established by proof of acts and conduct, as well as proof of any expressed agreement. When persons associate themselves in an unlawful enterprise, an act done by any party to that conspiracy to further the unlawful enterprise is considered to be the act of all the conspirators. However, each person is responsible for the acts of the others as long as they are the natural and necessary acts to further that conspiracy. When one or more persons conspire to commit any crime, any one or more of those persons does any overt act to bring about the object of the conspiracy. So the planning happened. What was the next step? Bringing masks and guns, that's an overt act. Taking a picture, texting it to the other car, that's an overt act. Presence, companionship, and conduct before and after the alleged offense may be considered in you determining whether or not those circumstances, if any, give rise to the existence of a conspiracy. Other involved parties. I know we heard about Young Bands, Boss Coleman. Any party to a crime who did not directly commit the crime may be prosecuted for the commission of the crime upon proof that the crime was committed and that the person was a party to it. Now, and the court will read this to you as well, and you will have this factor with you. This second crime, it is not relevant to your deliberations that other individuals who may have been involved in the planning or commission of the alleged crimes are not being prosecuted, or that only some of the defendants charged in this case are on trial. You are considering only the 2 defendants presently on trial. Intent. Intent is purposely doing an act. Intent can be inferred from the proven facts and circumstances or by acts and conduct. It may also be inferred when it is, you see this again, the natural and necessary consequence of an act. It is natural and necessary, or it is a natural consequence that if you go in to rob somebody and someone fights you back, that someone may get hurt in your conspiracy. You may find intent through words, conduct, demeanor, motive, or any other circumstances connected with the acts related to the alleged crimes. So let's look at the before. The before, it goes to the intent and conspiracy. So before the home invasion, there was a discussion. You heard testimony from Lauren and Lyndsey that there was a discussion amongst the defendants about what they're gonna do. They brought masks, they brought firearms. They did not bring their phones. Only the girls had their phones. The other phones were left at the house. You can use that as evidence of the intent to commit. They knew what they were about to do. Leaving Lyndsey's phone in the car. You saw Lyndsey and Lauren go into the house. Leaving Lyndsey's phone in the car would be that form of communication. Why else leave it? And turning off the headlights. You saw video footage of Lauren circling the block with the lights off at night. You can use that towards intent. Parking down the street. There was parking right outside the house. You can use that. During the incident, during the home invasion, like I said, texting Lyndsey's phone from Lauren's phone. Lauren running from Wiley Street, running from the front door all the way down the street to her car. You can use that as intent. Lauren circling the block. And taking the victim's phones. After the communications about the defendants discussing money, the split of money, or getting money. And then tossing the victim's phones. You can use that as intent. What was that the intent to do? They took at gunpoint, and then they tossed them to not be able to call the police. I don't know, but they tossed the victim's phones, and you heard testimony that later found. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Criminal intent is not the intent to violate the law. It's the intent to commit that act that is prohibited by law. So let's run through the charges. I broke them down, and I think a way to digest it. 1, home invasion. That's count 1 of your indictment. Count 2 through 8 is armed robbery. You got 7 counts, you got 7 victims. 9 through 15 is aggravated assault with a deadly weapon. 7 counts, 7 victims. Aggravated battery. 1 count of aggravated battery, and that was to, remember DJ Victor, the time. Aggravated battery. Number 18, participation in criminal street gang activity. You heard all about this yesterday. That's count 18. Count 19, possession of a firearm during the commission of a felony. And then 20, possession of a firearm by a first offender probationer as it relates to Mr. Pritchett. You heard that yesterday. Kind of broke it down into 5 parts. Home invasion. Enter the residence of another person without the authority with the intent to commit a forcible felony while in possession of a deadly weapon while the residence was occupied by someone with the authority to be there. You heard testimony from multiple people that Riggs was written out that spot. That was Riggs' place. He invited them, he wanted to be there. They were there. The defendants in this case, Robinson and Pritchett, entered without authority, with the intent to commit a felony once inside. You have evidence of that. While in possession of a deadly weapon. You heard 7 people. Well, you heard I believe 6 people say they saw the firearm. One person said they had their eyes covered. Armed robbery, broken into 4 parts. Took another person's property directly from the other person or the immediate presence by using an offensive weapon with the intent to commit theft. There is direct evidence. There are some eyewitnesses that said, I saw him snatch this off of me. He held a gun to my eye, to my face. But then, remember Christian Hooper? He said, I was curled up in the ball. I felt someone grab me at my waist, at my pants, and then I realized my wallet is gone. I came with my wallet, now my wallet is gone. After the 2 men came in, that's you can make an inference from that. His items were stolen from him. A person commits an aggravated assault when he attempts to commit a violent injury to another. The assault was made with a deadly weapon. Actual injury is not required for aggravated assault, and a firearm is a deadly weapon as a matter of law. So pointing at, toward, or in the direction of Holden Carmody, Noah Walker, Rebecca Mears, Jackson Buckingham, Vagat Katani, Christian Riggs, and Christian Hooper is your aggravated assault, each one of them. Aggravated battery. Aggravated battery is when a person commits an aggravated battery when he maliciously causes bodily harm to another by seriously disfiguring another person's body, greatly injuring the appearance of the victim's body. Disfigurement does not need to be permanent, but can be temporary. This goes to Vagat Katani's head. He told you that he still has scarring on his head as of now, but you saw the pictures of where he was at the time. Malice. Now, aggravated battery has an additional element of malice. Malice is not ill will or hatred. Malice is an actual intent to cause a particular harm produced, bodily harm, without justification or excuse. Malice is also the wanton, willful doing of an act with the awareness of a plain and strong likelihood that such particular harm may result. Intention may be shown by the circumstance connected with the offense. You heard direct testimony. In fact, one victim almost broke down. You heard direct testimony that Victor was curled up in a ball. It's almost as if they picked on him. He had nothing. He wasn't fighting back. He was giving up. And what happened? Curled up in a ball on the floor, he's still getting his head beaten, stomped on. That's malice. Count 18, criminal gang activity. A person commits criminal street gang activity when a member or an associate of a gang participates in gang activity while breaking the law. So you need the existence of a criminal street gang, which has been proven. You heard from the gang expert yesterday. The defendants are associated with the criminal street gang. We don't have to prove membership. Association is enough. The defendants participated in the charged criminal offenses. You have evidence of that. And then the nexus between the crime and the gang. And you heard that from the gang expert yesterday, that committed to furthering the interests of the gang. Count 19, possession of a firearm during the commission of a felony. A person possesses a firearm during the commission of a felony, and in this case, home invasion, armed robbery, aggravated assault, and aggravated battery, sorry, assault's there twice, and aggravated battery are all felonies. The court's gonna tell you that. And a firearm includes any handgun. Some people refer to it as a AR style pistol. Some said a pistol. I think somebody said a rifle. Firearm. All defendants, party to a crime doctrine, all defendants. It applies to all defendants. The last count, And remember, this is to Maxx Pritchett for his previous burglary. When a person possesses a firearm while on probation for a felony as a first offender. Home invasion, armed robbery, aggravated assault, aggravated battery are all felonies. And the court will instruct you with that. Thank you. For this time, I'm gonna stop with the law, and then you will, after you hear from the defense, you'll then hear from the lead, my co-counsel, Mr. Hiles, about what else you should find that these defendants are guilty. Thank you.
Thank you, Ms. Green. Ms. Mignot, you are up.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. On behalf of my client, Mr. Tyrone Robinson, his family, my entire staff, including my staff here, and our firm, we'd like to take this opportunity to thank you for your time and attention to the evidence in this case. If I look nervous, I can assure you it's not an act. I am nervous. And the reason I am nervous is because I have this young man's life in my hands today. I have removed my mask to make sure that the final opportunity I have to address you all as jurors, that you can hear and you can see movement of my lips. When we did opening statements for you, we told you what the evidence would be in this case. And as attorneys, we're trained, do not tell the jurors what you're not going to be able to show in your case in chief. And I submit to you that I'm about to point to you that I showed you what I believe the evidence in the case was to be. If you have any doubt about how this case came about, I'm going to give you the theory. As I prepared to address you today, the things that I did was pray, pray, and pray again. Because I did not want to say anything that would cause you any alarm or to upset you. So if there's anything that I have done throughout this entire trial, please, please, please do not hold it against that young man. I am an advocate, and I've been taught advocacy skills. And sometimes advocacy can come across as arrogant or harsh or aggressive, but I assure you, please attribute it to the passion and the oath I took to represent individuals like Mr. Robinson in my quest to uphold the Constitution of the state of Georgia and the Constitution of the United States. You all were sworn twice in these proceedings. And the reason you were sworn is because we're asking you to give us the truth. We're asking you questions, we're trying to select, trying to determine who can be fair and impartial. And fair and impartial, ladies and gentlemen of the jury, is a conclusory statement. How would I describe it? I don't like her pink suit, but I'm fair. And I'm impartial. So I'm gonna look at the evidence, and I'm gonna decide this case based on it. I don't like how she cross-examined, but I'm fair. And I can put that out of my mind, and I can focus on the evidence in this case. We're gonna talk about the pink elephant in this case. It's a subject that we as human beings don't like to talk about. But it's a subject, if we don't talk about it, we lose an opportunity to be the greatest country in the world. The state wants you to believe that this case is about lime green, slime green, highlighted yellow, but it's not. It boils down to its common sense denominator. What is that? Black and white. Our theory of this case, and what we believe the evidence showed you, is that you have two young white females that I told you in my opening are living a double life. In one life, they're wonderful children, they're going to college, they're doing the things that we as parents want them to do. And in another life, they're criminals. And I submit to you that the state decided, when this case started, that they like the girls and they want to help them. So what happened? Riley and Kallish conspired a plan to rob their friend from high school, Chris Riggs. Why are they trying to rob Chris Riggs? Because he is a drug dealer. He's an easy target. He doesn't have a whole lot of guns. He's gonna come with the ketamine. He's gonna come with the wax. He's gonna come with the gummies. He's gonna come with the marijuana. But he's not gonna come with a gun. Because he's a drug dealer that schedules parties and invites our young children to partake. Is that a problem for the state? Evidently not. No charges. Remember, I told you in my opening statement, the state has the legal authority to treat you as a victim in one case and prosecute you for your crimes in another. There's no or, there's and. They didn't do that here. So what happened? The young ladies go down and they speak with law enforcement. Detective Maldonado. Detective Maldonado says, tell me everything. They tell him everything. He says, I don't believe you, because they first told him. Guess what? It's just two of us in that car. But I asked you to filter the evidence in this case through one theme. And that theme is, oh, what a tangled web we weave when first we practice to deceive. And I'm not just talking about Kallish and Riley. I'm talking about some of the state's conduct, this return. Because what they want you to believe is that this case had nothing to do with anything other than gangs, lust, guns, and the list they put up for you in their closing of their case. It's more than that. Detective Maldonado questioned these young ladies. And I asked him, sitting right there in that stand, they were suspects when you questioned them the first time. Yes, they were. But what we did is, we're smart for law enforcement. We question them first, we pretend like we're gonna allow them to leave, and then we bring them back in, read them Miranda rights, and then question them again. So how do we preserve our case if we're the state? We preserve it with immunity. Because if the statement wasn't obtained lawfully, how are you gonna use it if you're trying to get to Mr. Robinson? You gotta give immunity. So now the state decides to do what? To give immunity. Let's talk about the list of witnesses they called. Ladner, Grady, Weems, Bygrass, Buckingham, Heil, Carmody, Walker, Meir, Sluss, Hooper, Riley, Catani, Briggs, Kallish, O'Hare, Velasquez, Miller. None, I crossed them out, none of them put Mr. Robinson in the house. None of them put Mr. Robinson in the Mercedes. So let's talk about what the witnesses said. Let's break them down for you because we threw a lot of information. Ms. Latner, she's a custodian of records, went through her pretty quickly. No information regarding who was involved in the incident. So the first witness the state gave you, no proof beyond a reasonable doubt. Mr. Robinson was involved in any crime whatsoever. Next witness the state called, Mr. Ian Green, went through him pretty quickly. Does not know anything of the people involved. He doesn't even own the Airbnb. He rents, he's a tenant of the Airbnb, and he mentioned the name of another owner. And he rented the property to Chris Riggs. Who's the next person we talk? Officer Roxanne. She's a responding patrol officer who met with the victims outside. She didn't even go inside Wilder Street. Why would a police officer that shows up and is a responding officer that's supposed to fill out a police report, take in, go inside, oh my God, I found drugs in plain sight. Wait, we have two situations here. We got a crime scene that I have to preserve, everybody outside, ward it off. Let's make sure nothing is moving here so we can gather all the evidence and make sure we have the right people. That didn't happen, she told you she didn't go inside. She cannot identify Mr. Tyrone Robinson when I asked her. So, no proof beyond a reasonable doubt based on this witness that Mr. Robinson was inside the house, or outside the house, or in the car, or outside the car. Next witness. Jonathan Vilas. He's a neighboring property. He had surveillance, and he provided the surveillance. Shows two men, doesn't show two men anywhere on the surveillance video going into the car, because that's important. That's important. The state talked to you about circumstantial evidence. You have to have a circumstance before you get to circumstantial evidence. You don't get gas in your car when you don't have a car. You don't get to a gas station if you didn't drive to a gas station. So this, when you drive your car to the gas station and you put your gas pump in there and you press and you didn't even have a car. They didn't even show you a car. But they want to talk to you about circumstantial evidence associated with gas going into a car at a gas station. This gentleman did not put it in there. Jackson Hiles. Jackson Hiles says, works in drug sales. Now Jackson Hiles is a very confident young man. But he's confident because he has immunity. Selling drugs in Atlanta, bringing it from California. It was mind-boggling to me as a parent, not even as an attorney. You got through TSA. Nobody has any type of machinery that's screening that drugs is coming from California and it's making its way to Atlanta, and then they're flying to Texas to a concert. He testified there was $15,000. That kind of money at that age? Within 28 hours in this city? Because remember the testimony of one of his friends was, we were here about 28 hours. 28 hours they were able to make $15,000. Cause he said, hey, I was coming here, I was gonna meet up with Chris Riggs on, I met him on social media. How do you think he met Chris Riggs on social media? Chris Riggs, remember, is the guy who's having the parties. The parties that Kallish and Riley had attended before. Drank alcohol, underage drinking, smoking marijuana, taking a dose of ketamine, something that can kill you. To hallucinate, to get a bigger high. What did he say? Can I identify the two people? So even with this witness, you don't have Mr. Robinson inside the house, outside the house. The description of your assailants differ. One was tall, one was really skinny. There's two masks there. One went upstairs, one didn't go upstairs. The alleged victims were inconsistent. And they were inconsistent, ladies and gentlemen of the jury, because they were covering. One of them called 911. The other one says, hey, hang up. What are you doing? We got all these drugs here. I'm not trying to go to jail. We're not trying to take everybody to jail. We're just trying to sell drugs. And they're like, having a great weekend on our way to the Travis Scott concert. Well, Carter disagreed about the state with the type of weapon. State is saying, hey, it was this. No, it's an AR, it's an AK, it's a short, it's a rifle, it's a pistol. We got descriptions all over the place as it pertains to a weapon. Doesn't place Mr. Robinson at the home. To get the home invasion, he's got to be there. Other than that, I'm the person who did it. My staff is the person who did it. Anybody sitting in the courtroom is the person who did it. It's not the standard. It's beyond a reasonable doubt. And you can't even get him there through this state's witness. They conceded that in their opening. Oh, none of the victims are gonna say they know who it is. They don't know who it is. So what did we do? We twisted the arms of the two girls when they said it was just them. Because we know two people went in other than them. We don't know who those two are, but any two Black men will do. Especially if they're in rap. Especially if they rap. 3 or more of them, gang, rap music where they use profanity, gang. There's a saying we come up with, there's say, throw enough stuff on the wall, something's gonna stick. That's what's going on here. Noah Walker doesn't have a clear memory, was very intoxicated. Spoke about a condition I had never heard of Asian women. Cannot identify Mr. Robinson as the person who took the cell phone. State's indictment says that my client, Mr. Tyrone Robinson, took a cell phone from Noah Walker. Through this state's witness, 0. No beyond a reasonable doubt that he was inside that house. Next witness, Rebecca Muir. She knew Christopher Riggs from high school. Riggs invited her to the party. She knew Noah Jackson. She knew Noah, she knew Jackson, she knew Holden. She said there was no interest to keep her alive. And what's peculiar about her testimony is, I asked her on cross-examination. So, did you see drugs? Nope. That's the see nothing, hear nothing, say nothing. I don't have immunity. Because remember, the person who brought the drugs, Riggs said, oh, yeah, $15,000 cash, lots of drugs, come to Atlanta to sell. That's what this was about. But he has immunity, so he has a reason to be able to share. What else did she tell you? 2 unidentified men after the girls left came in. That's not accurate. Because remember, one went to their car in a white jacket, which they switched according to the evidence, and one was still in the bathroom. She gave you men were black. She said she laid on the floor with her chin to the ground. She didn't witness any other violence. So the state is charging aggravated assault, aggravated battery. This witness can't give it to you. She can't place my client in the house at 1040 Wiley. She can't place my client in the Mercedes. And she can't place a weapon in my client's hands. This is not a guessing game. This is a prove your case beyond a reasonable doubt. Next witness. APD Officer Sloss, cell phone expert. And the cell phone expert gave you a cell phone record belonging to 2 females. 2 females' names listed on there. And then we want to play 3-card Monty. Well, although you see the name over here, don't pay attention to the name over there, because if I get my witness to just keep saying, Mr. Robinson's phone, Mr. Robinson's phone, Mr. Robinson's phone, then maybe the jurors will get confused and they'll say, oh, yeah, he did say Mr. Robinson's phone. If you're not gonna believe that the subscriber is not Mr. Robinson, then you're not believing the evidence. You're violating your oath. Because your oath is, oh, if that's somebody else's cell phone, other than law enforcement taking the stand and saying, that's Mr. Robinson's phone, doesn't make it his phone. Because every time I cross-examined on that issue, they would say, subscriber controls the phone. The subscriber controls the phone. I asked a magic question. Do you even know who that female is? What did Officer Sloss say? No. I don't know who that is. Could they have investigated? Absolutely. They have the taxpayer's checkbook as the DA's office. They could have determined who that person was and if that person was connected, but they did not. They thought it was good enough to just say it, and it's not good enough to just say it. What do you tell you? Provided, just go back one second. Provided cell phone account subscriber information is for a female, does not know the female, and does not have any records that connect Tyrone Robinson's phone to the 1040 Wiley Street location on the day of the robbery. That is critical. Because now if we say, hey, Officer Sloss is correct. He's not Riley, he's not Kallish, he's telling you he doesn't have any phone records that would connect Mr. Robinson to the 1040 Wiley Street. Cell phone tower evidence is important, ladies and gentlemen. And there is no evidence that his cell phone was associated with Mr. Robinson and located at Wiley Street. So if you can't even place Mr. Robinson at Wiley Street, we're done here. We're done. That's a not guilty. You can't place him there. You can't place him. And when counsel's talking about circumstantial evidence, let me tell you what circumstantial evidence would be. Cell phone being there, although we don't see him, that's circumstantial evidence. But circumstantial evidence can't get past that. Because if we're using circumstantial evidence, then that means I'm there. Everybody in this room is there. That's not the case. Christian Hooper. Mr. Hooper went to the party, he went with the DJ. He only knew the DJ, Victor. He recognized Lauren from Milton High. Milton High is important in this case. Because I'm worried that what high means in Milton High is the kids are getting high. Woke up, saw 2 people in masks. Could not identify my client. Cannot say that Tyrone Robinson, he couldn't even tell if it was a male or female of the 2 individuals that came in. And remember, there's testimony and evidence in this case that when they went to Young Band's house, there were 2 other people there. Who are those people? Did the state investigate? So those are 2 people that went? Next witness. Lauren Riley. This one is critical. When Ms. Riley was first questioned, she told Detective Maldonado that she went to Young Man's condo on November 7th, 2019. This is the night before the day of the incident. She sees two other people there. She doesn't recognize them. And she wants this jury to now believe, after she was in custody, because she told you to save herself, she says, I think it was baby Slack. I think it was baby Slack. I think it was Slack. But what do we have? The person referred to as baby Slack was not present upon her arrival. So whoever they're calling baby Slack or whatever the state wants baby Slack to be, there's lots of baby Slacks on Instagram. That's what their experts say, their detectives say. Slime comes up a lot, baby Slack comes up, all those things come up, because your handle can be whatever you want it to be. I could change mine to Slack tonight from the subscriber, and I have the account. What else did she tell you? Lyndsey got the Snapchat from Chris Riggs with the picture of drugs in mine. Now, ladies and gentlemen, that's important because the individuals in the house really don't want you to know that we kind of posted this on social media. Because it's out there on Snapchat. Well, we only texted to one or two people. But remember, they can't control who those people share it with. So although we have approximately 20 people at the party, who else knows about it? Because Kallish was present at a party like that before at a hotel. And if she's sharing it with Riley, who else is sharing it of the people they invited? She saw 3 to 4 people walking on the street before entering the AirBNB. That's what she told. She did not know the person referred to as baby Slack. You heard me ask the detective, if someone's never interacted with someone before, and it's the first time and only time they've ever interacted with that person, it'd be difficult for them to identify. And he said yes. She and Kallish were the only 2 people in the Mercedes when they went to the party. It's corroborated by the home surveillance video of the neighbor, Mr. Vickers. Those home surveillance, according to the evidence, is motion activated. So you could see the car going around because it picks up the motion of the car, and you never see, the testimony of the evidence is that they saw a white female, but at no time did they see anybody else in the vehicle. There wasn't, we could see the silhouette of 2 people in the back, we could see the silhouette of 3 other people other than the person that we could see. There's no evidence of that. She changes her story. And let me tell you something, ladies and gentlemen, I am not crucifying anyone that says, hey, if I'm in trouble, I'm gonna save myself. She's human. Of course she's gonna try to save us. But what we're saying to you is, not at the risk of convicting somebody who she's not telling the truth about. Not at that risk. She left the party before the 2 people entered. She did not see when 2 people entered or leave the Airbnb. So if she didn't see anybody going in, and she didn't see anybody going out, and she told Detective Maldonado that she and Kallish were the only 2 people in the Mercedes, that's a not guilty. Mr. Robinson is not placed at Riley Street. He's not placed in the Mercedes. He's not placed at Riley Street. She didn't see anything happen that inside the Airbnb. So she can't even say, yes, the whole plan was that I was gonna go in and you know, Robinson was gonna do this, and Pritchett was gonna do this, or Baby Slot was gonna do this. Because remember, the names Robinson, Tyrone Robinson, and Maxx Pritchett, she received from the police. She didn't give them that. If a police is investigating, they're supposed to be getting information. They're not supposed to be giving information. She cannot identify Robinson as one of the two people who went inside the Airbnb or exited the Airbnb after the robbery. We have no clue who those two people are. And we are not here to say, oh, no robbery occurred, no robbery occurred. Of course not, we're not the state. Something happened, people got injured, that is bad. But who did it? The evidence shows we know two people that are involved, Riley and Kallish. We don't know who else. The evidence is clear that there was illegal drug sales going on, rigs, piles. She is back in the blue jumpsuit. That's not a coincidence. That's a young lady who's not learning her lesson. Let's talk about the most important piece of evidence that we have in this case. Order granting immunity for Lauren Riley. The most important piece of evidence that goes to motive to lie, credibility of a witness, believability of a witness, is this document. And this is not a motion by a defense attorney. This is a motion by the state. This is why we're gonna have a hard time in this country stopping the opioid epidemic. Because when we find a source where it's coming into our county, into our community, getting to our kids, we don't shut it down. You know what we call it? A business decision. Mr. Riggs, tell us about your business. That's what counsel asked him. Oh, it's a business in California, and we sell drugs there, and I brought him here for sales because I was trying to hook up, and that's what I was doing. They make him a businessman. That's how he was depicted. So a white young man selling drugs is a businessman, and a black young man selling drugs is a thug, a robber, a thief, and a gangbanger. Gotta stop the hypocrisy to save our kids. We've got to stop the hypocrisy to save our children. This young lady is dangerous, and it's because she is not being held to account. And I know what the state's gonna say, she's facing the exact same charges as everybody else in this case. Then she should be sitting right there, like everybody else in this case. Next witness. Mr. Riggs. He received immunity to testify. He's a business partner for Jackson Heights. It's a source of drugs to our children. It's here in Fulton County. It needs to stop. You rented the Airbnb? He said, I was not doing much legally. Who says that? Was selling drugs. Knew Lauren from high school. Remember I told you, Milton High. Sounds like the word high means they get high there. One guy had a gun in his pants. Riggs was trying to identify it, but someone he knew had come for him. When he said that, all my ears went up. And I said, did he just say that he was trying to recognize the person because he thought somebody had come for him? Do you know why members of the jury he would think somebody's coming for him? Because they have these drug parties and they advertise them on social media. And they do know if they are keeping the doors locked, it's because they're concerned, who did we push this out to that might, instead of coming to purchase, come to take? That's why he's trying to identify the person. What they had last week? Couldn't tell you how tall the man was, up the stairs. Didn't identify Robinson as the person who took his phone or his computer. The indictment says that my client, Mr. Robinson, took his stuff. And he says, I don't know who the guys are that came in the house. So now you don't have beyond a reasonable doubt that Mr. Robinson is one at Riley Street, because I already showed you, we don't have any cell phone tower placing him there. We don't even have him with cell phone tower placing him where the state alleges his phone was left. Wait. I can understand you're saying your theory of the case is, no. His cell phone didn't ping at Riley Street because they were smart. They were smart enough to leave their phones back at young Van's place. Then why don't you have evidence in this case showing that the phone pinged at young Van's place? Because it didn't happen. You have to have a circumstance to have circumstantial evidence. Text witness. Lyndsey Kallish. She told Detective Maldonado she and Riley went to young Van's condo. So they were there. We're not disputing that. There were two people at young Van's condo. Nobody recognized. Did the state investigate who those two people were? Did the state investigate whether those two people were involved in the robbery? Did the state take video footage from young Van's expensive condo that's so expensive that somebody has to come downstairs and let you in the building? That's some tight security. Did they go do subpoenas to say, hey, let's see if we can see the car with the Mercedes with the two men that Kallish and Riley said left the condo with them, because the condo, trust me, is gonna have cameras in Buckhead everywhere. They're nice condos. They have security. Where is that evidence? You don't have it. You don't have it. Because they were satisfied with twisting the girl's arm with a promise. You just said what we're asking you to say. Just testimony. Just testimony. Because remember, none of the victims can place them there. So the only people who we can have place them there is you. One more lie for the road. But we'll just wink at it. State's motion to give them immunity, not a defense motion. Second most important document in this case. DR 16 was the first one, and DR 17. Immunity for Lyndsey Kallish. Immunity for Lyndsey Kallish. Get out of jail free card, get away free card, just testimony. Just testimony. State's gonna get up here and he's gonna say, that's only to protect what they say in court. Why do you need it? You need it because you questioned the girls and took a statement from them, violated their constitutional rights, and now you need to save your case. So how do you save your case? You give them immunity so they can come in and testify against these two individuals. That's how you save the case. And then we're long gone, nobody's looking. It's not on this. APD Scott here. He's a fugitive. We got through him really quickly. Because all fugitive means is, you got a warrant, you don't know you have a warrant, I come get you. If I have a warrant right now, fugitive would be going to my house. Is she here? No, she's not here. She's in court. She's at work. Okay, let me go to work. Go to work and begin. What else could they do? They could call me and say, hey, guess what? We have a warrant for you. Would you like to turn yourself in so we can save the taxpayers some money? And I would say, yes, absolutely. I'll be there in an hour. That's how that works. The word fugitive makes it scary. There's no charge here about fleeing or eluding. So don't let the word fugitive scare you. Right? Did not find any items at the time of arrest that connected Robinson to the 1040 Robinson. So there's not even a marijuana gummy wrapper or wax paper or one of the cell phones or a wallet, or we found, him with a weapon, or we found something that is similar. Nothing, ladies and gentlemen, nothing connecting Mr. Robinson to 1040 Riley Street. Detective Carlos Maldonado. Airbnb was rented by Riggs. Riley said she and Kallish went to the party alone. Both Riley and Kallish were suspects prior to their interview based on conversations with Bears and Hoover. He knew they were suspects. He was supposed to Mirandize them before he questioned them, but he did not. How do you save your case? Gotta give him immunity. Because there are only two people that can point the finger at my client and try to make you believe that despite cell phone tower evidence, the like thereof, that my client is at Wallace Street. No cell phones are placing my client at Young Van's condo. And if they said it, it's gotta be true. The two people that Detective Maldonado has admitted on more than one occasion on cross-examination, they lie. They lie, they lie, they lie. And when I asked both young ladies, how does this tree know when you're lying? They don't. You don't. Neither women knew the names. Nobody knew Tyrone Robinson. Nobody knew Maxx Pritchett. Nobody knew those names. And what you have is, I cross-examined Detective Maldonado. Did you show your cell phone while you were doing research in the interrogation room to them when they started saying slime? Yeah, first I was looking for slime. So he's actually on his cell phone in the interrogation room, looking up slime, looking up baby slag, or looking up slag, or looking, and then he shows it to the suspect. And says, oh yeah, I showed her, but I didn't show her the picture. Okay. Got some swampland for her. So say. Next witness. Detective Velasquez. This has absolutely nothing to do with my client, Mr. Tyrone Robinson. Court told you, took an oath and followed the law. That's got nothing to do with mine. He has no convictions, period. Investigator Miller. All right, so this is the state's gang expert. What the state really meant to say was, this is our coworker. And we've gotten a coworker that worked long enough in law enforcement that we could call on him and say, could you come and tell these jurors your expert testimony about gangs? When I cross-examined Investigator Miller, and I tried to give him the visual comparison to, I can be a member of a group, such as a fraternity, and the fraternity people could get in trouble or go steal stuff and bring it back to the frat house, and we could all consume it and share it. Of course, that would be for the benefit or the furtherance of the frat group, because we're all enjoying it. Just like how we wanted to give you the comparison of how the girls went and got the drugs and brought it back to the gang, and the gang used the drugs that was for the benefit of the gang. But he refused, he wouldn't concede that that would be the same comparison to fraternity. And I submit to you, that's because of his implicit bias. If you think that an employee of District Attorney Fonnie Willis is going to come into this courtroom and sit on the stand and testify as a gang expert for the state, the coworkers, and he's gonna say to you, oh, no, 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 no. It's more, you need way more. You need way more than just green, lime green, slime green, a handkerchief. You need way more than just finger signs that most people are doing in photos now. You need way more than a rap music video. I used to go to casting calls. I don't even think they have those anymore. But somebody would say, hey, guess what? Home Depot's doing a commercial, they need extras, shoot down here, they're paying everybody $100, for the day, and you run down there, you don't know anything about what's going on, you just know, stand right there, 15 people over that side, walk this way in the cart, people filming, you're gone. These are young, impressionable kids. He's 19 too at the time, 19 and 20-year-olds. You can't treat them differently. Because we're asking you for liberty and justice for all. Not for how the state wants to present liberty and justice for some. No evidence that Mr. Robinson is part of the game. Or YSL. But he's saying it. If I say it, then that makes it. And he told you, if you're a member, that's not enough. If you're wearing a color, that's not enough. You must commit a crime. And his hybrid triangle is not complete. Let's talk about why. Milton High, if you look at the hybrid he showed you an engine versus electric car, and that it created a Tesla. This is really the hybrid that we ought to be afraid of. The drugs are not coming out of Atlanta, they're coming into Atlanta. And they're coming from California, based on the evidence in this case. And they're coming from students who went to Milton High together, and they're making it to Wiley Street. And there's the hybrid, that's what they look like. Because the evidence in this case is that is the picture that Kallish received, that she showed to Riley, and Riley said, great idea, let's go rob. And she wants you to believe that, oh, we took the loot and then we went back to Young Vance's house, and when we got to Young Vance's house, we threw it out on the bed. Wait, we threw it out on the bed, but there was no sneaker. Wait, we threw it out on the bed, but then there was a sneaker. Wait, I think it's baby slap, but it's not baby slap, it's Tyrone Robinson. I'm not even sure if it's Rick, Rare, and baby slap that went into the house. We're all over the spectrum. This is the hybrid I'm concerned about as a parent. This hybrid, the Airbnb rental. Where's a 19-year-old or a 20-year-old that says I'm homeless, get money to rent an Airbnb? $15,000. Burden is on the state, ladies and gentlemen. They must prove Tyrone Robinson guilty beyond a reasonable doubt. The only people who say Tyrone Robinson was present at the party are the two women who got caught and now want to save themselves. And the state has decided to help with the saving part. So when I talk to you about first, we practice to deceive, this is deceptive. Know why I can say it's deceptive? Because the state did not show it to you first. You never said, when the witnesses were on the stand, hey, did we have a conversation? Yes. Did we tell you immunity? Yes. And are you testifying truthfully despite your immunity? Yes. No. They made me tell you. This is part of the deceit. You don't want them to know. Because if they know this, you might not be fooled that we didn't prove our case beyond a reasonable doubt. Don't forget it. Burden's on the state. State values together. The state. Filter all the evidence through the old wise saying. Let's talk about burden of proof, because that's difficult. It's a conclusory statement. I've been practicing so long and I still have not been able to, do I make it a trash can that I can pick up and show how heavy the trash can is? Do I push, the air vent around? Let's talk about burden of proof. If you say Guilty beyond a reasonable doubt, that's the word, has to be up there. That's it. Highly likely, not guilty. Guilt likely, not guilty. Possibly guilty, not guilty. Suspected guilty, not guilty. Perhaps still not guilty. May not be, not guilty. Possibly not guilty. Unlikely, not guilty. Probably not guilty. Less than likely, still not guilty. Totally not guilty. This is it. You must find one, that Mr. Robinson was at Wiley Street. You can't find, based on the evidence in this case, that Mr. Robinson is at Wiley Street. We're done. So not guilty. Don't follow the rap music track. Don't follow the scare tactic. Don't follow the slime or the slimy. Follow the law. And the law requires that you come back with the only verdict that justice demands based on your oath. And that is not guilty on all counts. Thank you.
Thank you, Ms. Mignot. Ladies and gentlemen, we're going to take a break. Ms. Rivers has been typing furiously as these lawyers have been sharing these important things with you. When we get back, I'll give the accused an opportunity to make his summation, and then we'll have the rebuttal or final summation from Mr. Hiles. Talk during the break whether you want to do lunch after all the closings are done or after the accused is done. We'll follow your lead on this one. But Mr. Hiles has a while to talk to you, so it could mean that lunch is more like 1 o'clock. If you can make it between now and then, that's great. Yes, sir. Logistical question.
What if we did an early lunch now? I don't know.
How about this? Why don't we take a quick break? I have to give Ms. Rivers a break. And you could actually tell Deputy Gordon, we're not coming back. We're going to lunch. For sure, come back. But it would be early. So talk about what works for you all. And so either way, we've got 2 pieces of closing left, and then the charge that I need to give you all. And you now drive the scheduling bus much more. So if you want to do lunch now and do the rest of the closings afterwards, fine with me. Just let Deputy Gordon know in a few minutes after you've conferred in private. Don't talk about the case yet. No outside research always and forever until you're done, but you will soon actually get to talk about the case, but not yet. See ya.
Sure.
Are you Investigator John? Okay, sit tight. All right, Mr. Hiles, anything before we take a little bit of, don't go anywhere. I might actually leave everyone right here. We'll go off the record and turn off the mic in a minute. But if they're going to go to lunch, you guys can be gone for a while. So let's just hear what their answer is. You'll get a break either way. I'll just get from Deputy Gordon in a couple minutes what that answer is. Anything you need to get on the record right now?
I don't think I need anything on the record right now.
Okay, Ms. Mignot.
No, Your Honor.
All right. Mr. Pritchett, anything? Okay, sit tight, all be seated, and Ms. Rivers, we're off the record. Ms. Rivers, are you ready? All right, we are back on the record in State versus Pritchett and Robinson. The jurors have returned from their lunch and are ready for Mr. Pritchett's closing as well as Mr. Hiles's part 2 of the state's closing. During the break, I shared with the state and with Ms. Mignot the proposed verdict forms, which are based on a proposed verdict form from Ms. Mignot for Mr. Robinson. There are obviously 2 forms, one for Pritchett and one for Robinson. Mr. Hiles, any objection from the state to either of the verdict forms?
No objection, Your Honor.
Ms. Mignot?
No objection, Your Honor.
Okay, I know you like the Pritchett one more than the Robinson one. You're good with both.
Yes.
Mr. Pritchett, any objection to either of the verdict forms?
No, sir.
Okay, then Deputy Gordon, if you would grab these from me and trade Mr. Pritchett 1 copy of that for the 2 verdict forms, and then 1 copy of that goes to Ms. Mignot and 1 to the state, and that is a final version of the jury charge based on all our discussions and exceptions, et cetera. I have in my hand the original that I will read to the jury later this afternoon, and which will go out with the jury during their deliberations. Mr. Hiles, anything else before we bring the jurors in?
Nothing further, Your Honor.
I will inform the jury that count 17 is no longer before them when I start my charge to them. Ms. Mignot, anything on behalf of Mr. Robinson?
Nothing on behalf of Mr. Robinson, Judge.
All right, Mr. Pritchett, anything from you? You ready for your closing?
Yes.
Great, let's bring the jurors in.
All rise for the jury. Mr. President, Tyrone.
Thank you, Deputy Gordon. Everyone else can be seated. So we didn't speak directly, but through my proxy, Deputy Gordon, I learned you all wanted to do lunch first. So you've all dined, hopefully, at least you had your lunch break. We are back together and there are 3 pieces remaining before you've got all the pieces you're going to get to the puzzle of the state versus Pritchett and Robinson. 1 is a closing from the accused, should he choose to do that. 2 will be Mr. Hiles's part 2 to the state summation, and 3 is the charge I must give you as to the law you must apply. So let me turn to the accused. Sir, do you wish to give a closing argument?
Yes.
Great. Now is your chance to do that. And I don't know where Deputy Gordon went. Do you mind? You went to the back. Deputy Gordon. Oh, you're on the radio. Deputy Gordon? Do you mind? We had to adjust the podium monitor when the defense one went out yet again. You just rotate that. I mean, you were having like a seance or something back there. I apologize. You can relight the incense when you get there. All right, sir, when you are ready.
Esteemed members of the jury, I would like to apologize because I know I missed the opening and I was failed to introduce myself. My name is Maxx. Nothing more, nothing less. My name is Maxx. I'm not sure what the beliefs are of the jurors are today, but you guys may hear me quote the Bible and reiterate principles mentioned in the holy text. And I know some may think that this has no place
in such a secular institution as this. But I would like to correct that by quoting from Public Law 97-280, which is a record of Congress and a stamp in legislative history. And it says, whereas the Bible, the word of God, has made a unique contribution in shaping the United States as a distinctive and blessed nation and people, whereas deeply held religious convictions springing from the Holy Scriptures led to the early settlement of our nation, whereas biblical teachings inspired concepts of government that are contained in our Declaration of Independence in the Constitution of the United States. The quotes of President Jackson, the Bible is the rock on which our republic rests. Whereas the history of our nation clearly illustrates the value of voluntarily applying the teachings of the scriptures in the lives of individuals, families, and societies. Whereas this nation now faces great challenges that will test this nation as it has never been tested before. Whereas the renewing of our knowledge of and faith in God through Holy Scripture can strengthen us as a nation and people. Now, therefore, be it. I say that to say, jurors, that today, in accordance with the Jews, it is a high holy day that is being observed, which is the Passover.
Objection, relevance.
So don't make relevance again as an objection in closing argument. You may have others, but Mr. Pritchett's gonna, as long as he isn't straying from the record, he is free to bring in his thoughts and perspectives. So overruled.
Action on evidence.
I will take judicial notice of the fact that this week, well, I don't know that it's this week, it had been last week, but either way, Mr. Pritchett, why don't you press on?
Okay. The title of these high holy days is the Passover and the Feast of Unleavened Bread. These days were to be observed by the Israelites forever. It serves as a reminder to them that God's judgment passed over them, but struck down the Egyptians. The Lord's judgment passed over these people because them and their families' households were marked by the blood. Jurors, my innocence, my adamant repentance, dedication, and love towards God has led me to believe that I am marked and been marked by the blood of the Lamb, Jesus Christ. I want to now just first, again, extend much gratitude for your service. You guys have showed me much patience and tolerance when I know at times I was unintelligible with my words. At times I displayed a great lack of legal expertise. And even at times I wasn't even present for some of the proceedings. It was never my plan to go through trial with no lawyer. Major conflict and ineffectiveness arose from previously assigned attorneys.
Objection, facts not in evidence.
Let's not talk about any prior relationship, good or bad, you had with attorneys, okay? You're welcome to draw attention to the fact that you're representing yourself, but not about what happened outside the presence of the jury.
If cases were determined on who displayed the best legal charisma, I am aware I would lose. But jurors, as you already know, cases must be decided on if the state has proven every element of each charge beyond a reasonable doubt. And so I would like to iterate that I deny every allegation against me, and I believe you shall allow your judgment to pass over me and a verdict of acquittal on all charges be established because the state has not fulfilled their burden of proof. The evidence presented to us by the state shows only that there is a lack of evidence, that they are missing to prove every element beyond a reasonable doubt. But what was presented shows us that there were two gunmen, and according to the victims and the responding officer, Ms. Reams, that night, according to their descriptions, one male is a scrawny, skinny built, light complexion male. The other assailant, according to the victims and the responding officer, Ms. Reams, is a black male, heavy built and of dark complexion with a tattoo on their upper left arm shoulder. I have not one single tattoo. And it is clear that I fit neither description of the alleged assailants. From the deductions of the victims and the reporting officers, we know clearly that the state is not relying on this evidence to try and prove their case. We know that their argument and theory I say, is solely relied upon the testimony of Kallish and Riley. My question to the juror today is, what has either of these parties done to persuade you that what they have said about me is the truth? And even if you do consider their testimony, the fact still remains that every essential element of the charges against me has not been proven. There is no proof that I ever got in the car of Lauren Riley. There was no proof or evidence to prove I participated in any planning of such heinous crimes. Riley and Kallish do not know me from a can of paint. There's no picture of me with guns or near any guns. And I'm not someone who used drugs. There's no motive for me to even participate in these chaotic crimes. Because of the many questions that the state has left unanswered, because of the lack of evidence, it can be inferred that Kallish and Riley may be protecting any one of the dozen of the gang members that were found in their phone records. Many of whom, according to the phone records, they were in intimate relationships with. Such as Monty, who they are scared of because, according to them, he has a lot of firearms. Or Young Bands or Supreme. The list goes on to who these women can really be protecting. And due to the purposeful lack of investigation into Young Bands, the state, as I reiterate, leaves many questions unanswered. Who knows what the real reason was that the state and Detective Maldonado chose not to pursue charges on Young Bands? We may never know. And I know, this is all speculation. This is all just inference. But the truth is, it cannot be factually denied or rebutted by the evidence that was been presented. Riley, in her first and second truthful interview, what she said with Detective Maldonado, never mentioned my name. In fact, she said she genuinely did not know the males. And again, reiterated that she did not know their names. At no point in this case did these two women say they saw me go in 1040 Wiley Street and rob a party. None of the victims said they saw me enter that house and horrendously beat and stole their personal belongings. If you even consider the portions of Kallish's testimony that she provided a couple days ago, it'll be shown that she lied to her mother on a call that she had with Detective Maldonado the day of her second interview, where she told the truth, according to what she said. And she told her mother that she did not see anybody with any guns or masks. I know that when someone starts a lie, which she said she did at the moment she sat down with detectives, once someone starts a lie, the only way to keep up with it is to continue lying. And what better way to get the lie to be perceived as the truth than to get full endorsement by the State District Attorney Office of Fulton County, who promised them immunity. Excuse me. Ecclesiastes 3:16 says, "Moreover, I saw under the sun that in the place of justice, even there was wickedness." Now, I'm not saying that the state or the judge or any public official here or anybody is wicked. But I am saying that if someone is so politically motivated and fueled by their selfish ambitions, they leave the door for wickedness to creep in. We know that the evidence shown only truly shows a lack of evidence. And this lack of evidence has caused the state to reach in all directions to try and persuade you of their theory and its case. The state tried to reach in my past to try and pull out a previous traumatic experience of mine to validate their claims that are being made against me today. Did I plead guilty to that previous case? Specifically, I pled under Alford, which is specifically a plea that maintains your innocence. And it is only taken because you believe it was in your best interest at the time. And at that time, my older brother had just been murdered.
So, Mr. Pritchett, I'm not going to require the state to object each time. There's no evidence in the record what was going on in your family, tragic or otherwise, and there was no one who testified to that. So you need to limit your presentation to this jury to facts that are in evidence as opposed to things you think you may know outside the record that you've helped establish.
My options for sitting in jail for 3 years, last case, were to take that plea, go home and console my family through their grieving phase, or go back to 901 Rice Street, arguably the worst jail in the nation. So out of much distress and coercion, I chose the former option. And so, yes, there may be some things that can be said about me for choosing that option. But I know, like I know now, I did not participate in that crime or this crime. And instead of the state producing clear, solid, and convincing evidence, they try to persuade you using my past. Of course, they didn't bring up my present, though which is true. I have been locked up for the past 5 years, 4.5 years. But even then, there's not a disciplinary report that exists on my name. And as an ambassador of Christ, who is not under the law but under grace, I know the conduct I must keep and practice to finish this race of faith on earth. Am I perfect? Absolutely not. But the supreme wisdom of God has used false accusations against me to lead and align me on the path of righteousness and the purification of my heart so I can be a guide to the blind. The possible corroborating evidence that was presented by the state were cell phone records. But I would like to bring to your recollection that the state did not present any cell phone or even possible cell phone records from me to connect me to any of these accusations. And I say that to the fullest extent. There are no cell phone records or data before, during, or after that incident at 1040 Wiley Street that connects me to the crime or even any of the other supposed suspects of the crime. The state would try to say, I knew how phone records work because of my last case. And so they stated and made the claim that, that it was my motive to leave my phone behind. But again, they have not presented any facts or evidence to prove I left my phone, a phone subscribed to me, anywhere at any place. So many questions remain. And the weight of the doubt in this case against me surely outweighs the evidence. Why do you think I did not get on the stand to tell my story? Simple. My presumption of innocence has not been defeated. Again, so many questions remain. But with the lack of evidence in this case, we do know the answer of why these women would lie. That answer is they were promised and motivated by the state the opportunity to escape prosecution for this case, which is clear being that they were granted immunity. Ladies and gentlemen of the jury, the prosecution has even reached a depth far unbeknownst to me, as they tried to introduce photographic evidence portraying me holding a flag alongside acquaintances or friends, purportedly in a territory labeled as gang territory by the state. However, I urge you to consider this so-called evidence with a critical eye. First and foremost, holding a flag and a photograph does not equate to membership in a gang. The mere presence in a specific location does not automatically imply guilt or affiliation with criminal activity. How can I be in a gang and the state couldn't even show not one picture, not one video of me throwing up this gang's hand sign? Oh, that wasn't enough. How can I be in a gang when the state has not shown no evidence or fact that I even talk like and speak like one of these gang members? And I believe this shows the fundamental disconnect between this system and the people. And it has almost allowed this system to be degraded into a mere for-profit business. And his main customers, sad to say, are people that look like me. Let's not forget the Constitution and 13th Amendment still supports slavery. Again, I urge you to consider this so-called evidence with a critical eye. As individuals, we often find ourselves in various settings, some of which may be misconstrued and misrepresented by external observers, which clearly is the case with the gang expert that testified. Furthermore, the prosecution's attempt to link this photograph to the alleged gang involvement in the crime at hand is blatant misinterpretation of the facts. There is no concrete evidence connecting the activity depicted in the photograph to the events at the Wiley Street party home invasion. In fact, the state has tried to say that during that home invasion, a pair of shoes were stolen off one of the victims. And according to the victim's testimony, the shoes had a blue light. The picture was edited. And he said verbatim, the shoes were a highlighter yellow. According to that gang expert, the colors of YSL are green, lime green, red, and blue. I don't remember yellow ever being mentioned. I categorically deny any association with a gang or involvement in gang-related activities. My character and reputation stand in stark contrast to the criminal narrative painted by the prosecution. I am a God-fearing heavenly citizen, innocent of the charges leveled against me. And I implore you, members of the jury, to see through the prosecution's thinly veiled attempts to manipulate perception and construct a false narrative. The photographs presented as evidence holds no weight in proving my guilt. I ask you for your impartial consideration of the facts and your commitment to delivering a just verdict based on evidence and not conjecture. I can still smile. Highly esteemed jurors, do you want to know why I can still smile before you all today, even though I stand here falsely accused? It is solely out of my faith and knowledge of what Romans 8:28 states, and it says, and we know that for those who love God, all things work together for good for those who are called according to his purpose. Furthermore, the very nature of this case raises reasonable doubt. A rushed investigation, the absence of clear identification, and the lack of any definitive proof cast a shadow of uncertainty over the proceedings. Can you in good conscience convict me based on such flimsy grounds? Lastly, again, let's not forget the presumption of innocence. It's a cornerstone of this legal system, a principle designed to protect the innocent from wrongful conviction. And I stand before you today as an innocent individual whose life hangs in the balance. The burden of proof lies with the prosecution, and they have failed to meet it. In closing, I urge you to consider the facts objectively. Do not let emotion or conjecture cloud your judgment. I implore you to uphold the principles of justice and fairness and to deliver a verdict based on evidence and not speculation, and not to forget the weight of doubt that lies in this case. I am innocent of the charges leveled against me, and I trust that you will see the truth. Thank you, and God bless you in the name of Jesus Christ.
Thank you, sir. Mr. Hiles, if you would set up whatever you need to set up.
Okay. Now I'm here to tell you why Kallish and Riley should be believed. At this point, it's clearly obvious that there was a home invasion, and it depends on who committed that home invasion. I wanted to first start with the idea of their initial interviews in the lie. They were kids when this happened, older kids, but the college-age kids. What do kids do when they are confronted with facts that they will get in trouble? Generally, they lie. The example that I can relate to when I was a kid, late teenagers partying, was stealing my dad's vodka and filling it up with water. I had younger siblings that were too young to be doing that type of stuff, but I did it. I put it back in the freezer, and when it came out frozen, I denied it till the stars came back. And that was how I was finally able to come clean, was because I was confronted with the actual evidence. There was no immunity given at the start of this prosecution. If you look at these immunity grants, they were granted in 2022, just before the case was supposed to go to trial the first time. What immunity means is that the state cannot take the words you say on the witness stand and use them against you. Otherwise, you would never have co-defendant testimony against another one, because you would be compelled to give evidence against yourself, which is a violation of your own Fifth Amendment rights. If that immunity is not there, and Ms. Riley or Ms. Kallish decide that she wants to take the stand, decides that they want to take their case to trial, then all the state would have to do is just replay the testimony that was given as they fingered their co-defendants as to what they were doing. Really what it comes down to is, where's the corroboration? How do we know that it was Pritchett and Robinson that went inside that house? Well, where does it start? It all starts at the Mayfair. It starts with young bands. Young bands is Voss Coleman. The same Voss Coleman that defendant Pritchett planned a previous home invasion style burglary with. You heard the 911 call. You heard the evidence that got him caught. Starts with the same people. 199th and 14th Street Northeast. It's called the Mayfair. This is the conversation that was pulled from Lauren Riley's Instagram accounts. We have undisputed evidence that this is their account. Also, this is where defendant Pritchett, Maxx, the one who just came up here and proclaimed his innocence, he was arrested at the same spot that it was planned. Again, corroborating what the two co-defendants told you. I'm going to go through this whole text thread too, because it's important. The messages are what corroborates what the girls told us. Just got back home, text me when you're on the way. This right here, this 678 number that we know is from Young Bands, that's the same 678 number that Lauren Riley is texting with in April. You'll have that text conversation, and I'll bring it up at the end of my presentation, but you'll be able to take that to the jury. That corroborates that Lauren Riley and Lyndsey Kallish actually knew were with Young Bands and Pritchett, who goes by Rick. Undisputedly goes by Rick. Both Detective Velasquez in 2015 when he was investigating Pritchett, Rick Rare. Now his Instagram account, Rick Rare. That hasn't changed. So this is in UTC time, it's not accounted for, but the reply to this message is, are you alone? Young Bands asks, why do you say that? He says, yeah. Lauren says, because Lyndsey is with me. What does Young Bands say? Oh, Rick's with me. He said he wanted her to come. That is Rick, the man that just got up there and proclaimed his innocence to you. Maxx and Rick are one and the same. That's the same individual that Lyndsey testified having sexual relations. You don't just pull that stuff out of a hat when you're trying to get yourself out of trouble. Lauren says she's parking. And then here's the most important question. You know, young Vance, he's known Rick, Max Pritchett, who he just said is with him. He said, Rick is with me. He's known Max since at least 2015. He is close. They've planned at this point two, or almost to this point, 2 home invasions together, both of which were going to rob drug dealers. Lauren says that she's parking. And what does young Van say? Okay, meet Max in the lobby. Max with 2 X's. There's not a whole lot of Maxes with 2 X's, but young Van is the only person that you would think would be calling Rick Rare or Rick Max because of how long the relationship goes back. All right, so once Lauren and Lyndsey arrive, they say they get a Snapchat. That's corroborated. Riggs told you he sent a Snapchat for one, maybe both. That's when the idea was floated. It is no doubt that Lauren, it was her idea. But when pressed, one thing Lauren did say was, well, how come, was asked, why didn't young Vance go? Lauren testified that he was on house arrest. This is why he was on house arrest. Big Slap. That name is not just pulled out of the air. In fact, what the defense got up here and told you is that they were going to prove to you, or they had shown you everything they were going to show you in the opening statements. But one thing that was said by the defense in the opening statements was, we are not going to run from the name Baby Slap. Client is Baby Slap. He's a rapper. You saw evidence of that too. But it's not just any random Baby Slap that they pulled out of the air as the defense makes you think, or wants you to think that there's thousands of them. This Baby Slap is directly connected to young Van, to Pritchett, to the whole plan involved in this robbery. This is the testimony. The Snapchat was sent, the plan is made. Baby Slap joins the group. Lauren drives to 1040 Wiley Street. A whole lot of noise has been made about the fact that you never saw the 2 men get out of a car. How do we even know a car came? You've only seen one car circling the block. You never see the girls get out of the car either. It's because it's parked around the corner and it was done intentionally. All right. Here's the video. Lyndsey and Lauren go in first. What did Lyndsey say she did? Or Lauren said she sent a text message to Lyndsey. She also said she deleted her text messages. What you see here is an empty file of an MMS message that was sent. Multimedia, that's a picture. You had to look for this actual HEIC number to get the image inside the records, but this was the image that was sent from Lauren's phone to Lyndsey's phone, which wouldn't make sense if both girls were in the house together. The reason it was sent was because Lyndsey's phone was in the car with Pritchett and Robinson. Baby Slap, Rick Ray. Lauren told us that she stole some wax. It makes sense exactly why she would switch jackets with Lyndsey. Everything's adding up at this point.
What do you guys have them? Oh, yeah, I do.
Everything she said happens is corroborated in the video. Here's the entry of the suspects, Pritchett and Robinson. At that point right there, you see who I believe to be defendant Robinson pull out an AK style pistol. And I'll tell you why you should know that that was defendant Robinson who pulls out the pistol in just a minute. Clearly, the defendants were inside during this incident when she left. You can hear him say, "Bring out your phones." You can hear the beatings going on inside. Now look when they leave. See those bright shoes that everyone's talking about? They made a deal, tried to make a big deal about how do we know when shoes were taken? Did I see them? Did I not? Quite obvious that the person to be Pritchett, not Robinson, keep in mind these shoes right here that Robinson's wearing are very telling. But that's also the reason Pritchett keyed in on those shoes. That's the only thing he keyed in on this whole trial, because he knows what they look like. It's the brief clip of the Mercedes without the lights on. This clip right here is at 2:19 a.m. This is Mr. Vivres's, Regaris, this is his system, his security system. Now, this is the correct time. You can see it displayed on the digital videos if you choose to watch these again. The timing on the other side of the house is exactly 30 minutes off from this. But we know this is the good timing based on when the 911 call was made. 911 call comes in just after 2:23 a.m. on November 8th, 2019. This is the aftermath. Mr. Gattani, he had his head split open, he testified to his skull fracture. I put this in here because I want to make one thing, one main point when it comes to the aggravated battery against him. It says serious disfigurement. That's any disfigurement. You can't see it. Even if it's not permanent, it still constitutes serious disfigurement for the count of aggravated battery. We know a home invasion occurred. Blood on the floor matches everything that the defendants told us. Now, I really don't care that they were partying. I mean, it is a deal in a sense because of the heavy drugs that were involved, but there's been a big mess made about why they're not prosecuted. In order to prosecute somebody for drugs, you have to have the drugs or have to be able to prove beyond a reasonable doubt that these candies actually contain THC. Well, there was no drugs ever recorded, even if recovered, even if all the officers went inside, because these two defendants stole them. There's nothing there to prosecute. The evidence was literally the target of the armed robbery, the home invasion. Got these in here. This is the actual property each defendant said was taken from them. That's the basis of the armed robbery. Wallet for Mr. Carmody, wallet for Mr. Cooper, wallet for Noah Walker. Rebecca Mears had her phone taken. Jackson Buckingham, remember he testified he had four names. Buckingham and Kyle are one and the same person. It's just the Buckingham is what was on the police report in the indictment. It was actually, Mr. Gutani had his, not shoes, but his phone taken, and Riggs had his computer taken. Lyndsey testified that things were being thrown out of the car on their way home. And that, again, is what is corroborated as these wallets are found by people in the neighborhood. Cell phones are tracked down the street by the witnesses with the Find My iPhone app. And even I believe it was Ms. Mears said that a homeless individual actually picked up her phone and she met her somewhere around Woodruff Park to get the phone the next day. That's corroboration. Stashed in the Mayfair, the testimony of Kallish and Riley is that the edibles were all dumped out on the bed. They were promised that the drugs would be sold and that they would get a cut of the proceeds. And it's the conversations between Lyndsey and Lauren in the coming days that is all the corroboration that is necessary for this case. They are naming Rick and Baby Slap and name on November 8th, 9th, and 10th. The day this armed robbery, or the day and 2 following days after this armed robbery home invasion occurred. They're saying they're trying to reach out to young bands to get this stuff. We have that digital records. This is 8 days before they were even suspects. 8 days before. The police didn't tell them anything they didn't already know. And we know this because it's in the records. All right. I want to talk about this. What was it that was said by the defense? Oh, what a tangled web we weave when we first practice to deceive. When Detective Sluss came and testified, I entered these phone records, the T-Mobile phone records, correct? And that is what he spoke to, the call detail records. Detective Sluss, in his testimony, said, there are no timing advanced records. Timing advanced records are the records that tell you where exactly inside that little area the person is located when he calls. Well, when Detective Maldonado came to testify, the defense attorney put in DR-18 and stated, you have no records. This proves that there are no return of records. Any records you gave were a lie. But what the defense DR-18 says, it says, unable to respond to your legal demand for the following reasons. In regard to identifier 470-646-4757, no timing advanced records exist. She put this into evidence as proof that Detective Maldonado was lying about ever getting call detail records that have been admitted into evidence and talked about by Detective Sluss. Now, this 470-646-4757, this comes directly from Baby Slap's and Tyrone Robinson's Instagram. It is verified. That means there was a text sent to that Instagram account that responded stating, yes, this is our number. Robinson Tyrone 999@gmail.com. All the identifying information. They were just cross-examined, and how do we know which Tyrone Robinson this is? There's 2 Tyrone Robinsons. Well, we know because there was multiple days of back and forth where I was showing you how the linked media can be traced back to the PDF document. It is the exact time pictures and videos were posted. Those were undoubtedly pictures and videos posted by that defendant. Now, I cannot get up here and tell you anywhere in this little bubble exactly where the person who made this phone call was, the phone associated with Tyrone Robinson, because I don't have the timing advance records. But I do know, and from Sluss's testimony, is that a call from the Mayfair at 3:30, just after 3:30 on, at 3:35 on November 8th, 2019, that would be consistent. That is the tower that you would expect a call coming from the Mayfair to bounce off of. That's corroboration. That's saying that after the robbery where the girls say they returned with the defendants, that's where the call, is consistent with the call being made from the Mayfair address. All right, the shoes. Look at the shoes. You can see the red in Mr. Robinson's shoes. I pointed it out when he was leaving after going into his home invasion. Go to the next slide. This is one of the pictures that was recovered on the phone that was taken from his person. That same phone having multiple text threads stemming from that 470 number we just discussed. It was taken off his person. Incredibly similar shoes. I would argue, I'm submitting that they're the same shoes. AR style pistol. Same shoes. That gun. We know that there were guns involved in this home invasion. That's not a question. We know that the defendant had that same gun. Again, multiple YSL members, each holding up a different YSL sign. The green flag next to the firearm. That same firearm going into the AirBNB. All right. Communications about the money. Lauren Riley through Instagram directly after the robbery where she said was planned at Vans' house, text Vans and says, "Are you even going to give me any money?" That's quickly followed up by she was blocked. Blocked by young Vans. He didn't want any part of this crazy chick. They got the money, she's not getting any. This is the conversation that is all the corroborating evidence that you should need to understand why the girls are telling the truth. Why it's these two individuals. They have not even been made suspects at this time, let alone questioned by police as to who they are talking about getting the money from. Van said he needed to get the money from Rick. Or keep asking for the money. What you mean? Like, you need to keep talking to Rick until we get the money. Rick is Maxx Pritchett. His Instagram is Rick Rare. It's got his profile picture in the Rick Rare. And he was called Rick Rare all the way back to 2015 when he was part of the planning and execution of another similar crime where he went to rip off another drug dealer. So Baby Slat and Rick are still talking to me. That's good. That's on 11/9/2019 at 4:37:38 UTC. Subtract 5, so that's 11:37. Remember, UTC during this point, subtract 5 hours. On the 10th, can you ask Rick and Baby Slat where the money is? Lyndsey responds, yes. November 10th, 2019. See, this is possibly, it is the most damning for Mr. Robinson, identifying him with the Baby Slat that Lyndsey said she was talking to, who she believed committing the robbery with. These target numbers cannot be changed. It doesn't matter what you do. cannot be changed. Lyndsey, text him the F word. There's a normal conversation about what type of hairstyle are you fixing to get. Lyndsey makes some dumb comment about not being able to keep up white girls' hair. And then Lyndsey, to baby slap. We need to sell that shit and get a big dinner because I need some crab legs. This is November 9th, 6:50 p.m. She's told to just chill. And then if there was any question as to whether or not this was baby slap's account, she refers to him by name. What's the word? Baby slap. Presumably in another attempt to get the money that only the YSL members are keeping. Only the YSL members. Robinson, Pritchett, and what you heard the testimony from JP Miller is that Young Vance has been documented as an associate. He couldn't say that he's an actual member, but keep in mind, we'll talk about it later, you only have to be an associate of a gang to be part of a gang crime. This is the same conversation reflected in Lyndsey's phone. Lyndsey's phone, however, is already accounted for the Eastern time -5, but she says that it's the exact same conversation reflected. These girls, they didn't have time to make this up. They were kept in separate rooms at the interview room when they got to the police station for interrogation, and they were never allowed to communicate again. Can you ask Rick and Baby Slap where the money is? That's Lauren's phone number. Lyndsey testified that Lauren was saved with Sugar Mama in her phone. It is the same date and time reflected. The video, Play Nasty, it's in evidence. You can watch it again if you need to. I don't feel the need to play a whole music video for you guys again. But look, it's literally filmed at Young Van's apartment, the place that this home invasion was planned. This is a screenshot from the video. You can see the same painting in the video. Throughout the video, it's filmed at night, but you can see what I believe is the 22nd floor, 20-something floor. You can see the views. You can see all the same artwork throughout the music video that you can see in the actual body camera footage of where Pritchett was arrested. These aren't some casual connections. Pritchett's name wasn't just pulled out of thin air. Rick wasn't just pulled out of thin air. He is always in the mix and has been since 2015. Instagram, remember this video right here? That is the story on the right side of the screen that was posted on Tyrone Robinson's Instagram account. On the left side of the screen is the picture that I showed yesterday, recovered from Tyrone Robinson's cell phone, that shows it is the same phone number, the same phone associated with everything, and the same number posting to the account. Now, what's even more telling about this picture, look at the name of the song that he posted about with Young Vans. It's Partner in Crime, literally and figuratively. We're getting into the membership. There was a lot said about, oh man, it appears that you just took screenshots from one music video. There were several pictures in that phone dump that appeared to all have been taken at the video shoot. I'm not denying that. But what is clear is it was taken with known gang members, displaying known gang signs. with the gang colors. You cannot get away from it. Just an illustration, these are multiple pictures taken on different days out of Robinson's phone number, all throwing up the YSL. Rick Rayer, you can see this screenshot taken from Robinson's phone, and you can see the profile pic of Rick Rayer. Rick, bands, baby slap, all together, all throwing up the gang sign. The middle picture, I think this was all taken at the same gas station at the same time, but it is posted by on accounts of 3 separate known gang members. So I'm Santana in the middle one. Snake love all the time, slime love all the time, Slat. The name Baby Slat is synonymous with YSL. Look at the, we ain't with the rap shit, 1100 snake pit. We gonna take something. I had to tell my partner to chill because he gonna whack something. That we ain't with the rap shit, we're not just singing about this stuff. We're not just artists. We're out here in the streets living out what we're singing about. Pritchett got up here. He is incredibly intelligent. I'm not going to deny that. It's a shame of what he's using his intelligence for. It is very sad. He knows from past experiences to keep his social media clean. You heard an exchange that he had with the defense about having multiple social media accounts from the first time he got arrested. He watched his friends go down in that same case because of their social media. What does he do? Lyndsey and him were only texting over WhatsApp. That's the only way he would communicate with her. What did we hear about WhatsApp? 1, it's encrypted. 2, a single party can delete the entire conversation on their own from both devices. That's the testimony we received. He's got an education in the streets. He's done it before. He knows what will get you caught. Of course, there's not any phone records putting it in the Mayfair or at the other spot. I don't even think he wasn't even arrested with a phone. We couldn't get a verified phone number for him. He walks smooth. All right, this iron triangle, the gang, the person, the crime. YSL is a criminal street gang. Investigator Miller himself has interviewed over 20 members. The person, I believe we've shown both Pritchett and Robinson, their affiliation with the gang. Even if there's no pictures of Pritchett throwing up gang signs, he knows to keep his social media clean. But what's telling is who he is with and what he is holding. And if you don't want to believe that he is a member, that's fine. An associate, you have, the gang count says member or associate. He cannot run away from being an associate of this gang, which when you commit crimes and furtherance of the gang, is just like you're a member. Crime. The home invasion, all right? It is executed, the actual physical home invasion executed by 2 YSL members. 2. What's telling is how does that benefit the gang? Well, only the YSL members got to share in the proceeds. The others were cut out. It is only the gang that benefited. Lyndsey and Lauren thought they'd get a quick score, some money to fuel their whatever addiction issues they had at the time, whatever lifestyle they wanted to live. But that nexus, that connection, to the crime, the gang, and the person. It's the fact that only YSL benefited from the proceeds of that robbery. I just spoke on this slide. Not every detail needs corroboration with co-defendant. That's impossible. You're never gonna have full corroboration. You just need a slight corroboration. So how do you know that it is not just one person trying to get out from under being in trouble and lie their way out of it? Well, Lyndsey and Lauren were caught. You can see the corroboration in their cell phone messages to each other. You can see the corroboration in their Instagram messages to young fans, to baby slapped. This is even before the police even got involved. Next couple slides, young fans. Speaking with Lauren prior. This is the same cell phone number, that 678 number, that same cell phone number that texted Lauren, or Instagram, it was sent to Lauren over Instagram with the address to the Mayfair. That same Instagram message that said, Rick is with me, bring him over. Bring over Lyndsey. This exchange. Do you need something? Call back. Nah. You're lame as fuck. Then on the 12th of April 2019, just after 3:07. So it's in UTC time, so it's going to be about 10 p.m. Just Rick, again, Rick, Maxx Pritchett, texting through somebody else's device. This isn't something new that we saw with the evidence gathered at the beginning of the presentation. This is something that's been going on for months. It's Rick. Tell Lyndsey to call me. The same Rick that Lyndsey admitted to a sexual encounter with. These girls love bad boys. That's what got them off. That's what drew them to this. But this isn't something new, and it's not something they pulled out of their backsides to get out of trouble. Now, they might have been pressed with irrefutable evidence of their involvement before they came clean. And I'm not telling you that they don't have motives, that they hope they get treated better. I'd be a lie. They told you they did. But this idea of immune from prosecution, what they are immune from is the state using their testimony from only what they said on the stand against them. That cannot be played. Anything garnered from their testimony cannot be used to prosecute them for this case. Another thing that I want to point out about that order granting immunity. That's not a state granting immunity, that's the judge granting immunity. Only the judge can grant immunity when it comes to the testimony in the court. That is his order. Beyond a reasonable doubt. Every single one of you knows what that is. It's not it's a picture of a $1 bill. Beyond a reasonable doubt is not above all doubt, beyond all doubt, as in that mechanism that that chart that was shown to you by the defense. It is doubt that is reasonable. The idea that you can't put Mr. Robinson or Mr. Pritchett in that car. We know that Lyndsey and Lauren had to take a car from the Mayfair to where they were at 1040 Wiley Street. It's too far to walk. They didn't Uber. You see them, the car circling on the camera. There weren't any drugs or guns that were seen in the car prior to going to the house. Lauren testified that she saw a gun being placed into a backpack while they were leaving the Mayfair. And Lyndsey said she didn't see any guns prior. There's no reason not to believe her. That's that bad. There's always going to be questions left unanswered, but an unanswered question doesn't mean reasonable doubt. You know beyond a reasonable doubt what this image is. The drugs that were dumped on the bed didn't just appear out of nowhere. We saw the two masked men go into the building. Whether or not they were wearing gloves or you could see their wrists, I don't think that all of the victims in this case, victims, even though they were doing some illegal stuff, they are still victims that were violently beaten. I don't think they're gonna remember every detail about every person. One, being intoxicated. Two, just the traumatic nature of this event, let alone that they're up here testifying almost 5 years later. But what we know beyond a reasonable doubt, based off the evidence that we can directly see and what's told us, is that these two masked men go into a house, severely beat two individuals, steal shoes off of somebody's feet that are in evidence that are lime green shoes in the picture that was taken by him. The only shoes that were taken are these lime green shoes, highlighter yellow. The picture, you'll have in evidence, you decide what color they are, but they are undoubtedly the colors of that gang. Another motivator for taking those shoes. It's even testified that as the individuals were leaving, the shoes caught their eye and they came back and took them. It's beyond a reasonable doubt. Now, Pritchett and Robinson, baby slap, Rick Rare. It doesn't matter if you see him getting in neither court. You know they had to. That's the whole circumstantial evidence that we've been speaking of. It's not some random robbery from some random people because it was posted on the internet. Snapchat's not public. It was testified that it wasn't public. Snapchats disappear once you send Snapchats. It's open and closed. Another testament. Even if it was, it's no coincidence that Lauren, Lyndsey go into a house, leave the door unlocked, and two armed men go inside. There's no other reasonable explanation other than the fact that it was Baby Slap and Rick Rare who committed this. And one thing Lyndsey was consistent with all this whole time and was trying to be brought up, she said Baby Slap wasn't present for the planning phase. She never wavered on that. And it makes sense. It makes sense. Bands couldn't go because he was on house arrest. Still fighting a charge where a man jumped off the balcony from a home invasion. It all adds up. Baby Slap, Tyrone Robinson, Maxx Pritchett, Rick Rare, that were the two armed gunmen. You can see their complexion of their hands on when they go into the house. That color shot when they first go in on the video is consistent with the racial makeup as what was described. Their builds, Pritchett's wide shouldered, especially back then. Nobody ever said they were fat, built like a linebacker. Robinson, skinny. He's bigger, he's built out a little bit now, but you can see the pictures that were put into evidence. Everything's consistent. But what you can't run from is the digital footprint that we leave behind in the 21st century. And that, combined with Kallish and Riley's testimony, is what sinks them. It's what proves beyond reasonable doubt that it was Robinson and Pritchett that committed this home invasion, 7 armed robberies, aggravated battery, 7 aggravated assaults. Each person in there said that they were terrified that if they didn't comply, that they would be shot. Imminent apprehension of great harm. This is real life Fulton County in which we reside. And I ask you to return to the jury room and return a verdict, the only reasonable verdict, which is guilty on all counts that are back there for your consideration.
Thank you. While Mr. Hiles is removing that equipment, do a seated hokey pokey or something, because I need to read the law to you. It's not as interesting. There are no videos, but you need to be awake for it. So do whatever kind of seated yoga feng shui you would do. And I'll get this going over here. Okay. I now need to share with you all the law that you must, not may, but must apply to the evidence as you find it to be. This is it. You're going to have this during your deliberations. Unfortunately, I can't just hand it to you and say, please read as your instruction manual. I need to read it to you, which I will in just a moment. You're welcome to take notes, but you will have this document from which I am reading during your deliberations. It's also going to appear on the screen right there. Some people like to see what they're listening to as it's being read to them. So you'll have it visually now. You'll have this later. And I need to clear up one thing. This is the indictment. You will get this during your deliberations as well. I have removed one count from your consideration. Count 17 alleged the aggravated battery of Christian Riggs. And the allegation was that Christian Riggs' nose was seriously disfigured. That is not going to be on the verdict form. There's no more count 17 for you all to wrestle with. There's still an aggravated battery count. So I'm going to tell you what aggravated battery is and what the elements are, but no longer for your consideration is count 17, one of 2 aggravated battery counts. All right, let's see if we can get this to work. Indictment. A grand jury has indicted the defendants for home invasion, armed robbery, aggravated assault, aggravated battery, violation of the Street Gang Terrorism and Prevention Act, and possession of a firearm during the commission of a felony. All those counts involve both defendants. Defendant Pritchett is also charged with possession of a firearm by a first offender probationer. To these charges, the defendants have entered pleas of not guilty. And as I told you at the beginning of the trial, neither the indictment nor the pleas of not guilty, which are the signatures on the second page. And so you're not surprised. I signed for Mr. Pritchett. He declined to sign. And when a defendant says, I'm not going to sign, I'm authorized to enter a plea of not guilty, never guilty, but not guilty. And so I entered the signature for Maxx Pritchett. But neither the indictment nor those pleas of not guilty are evidence. The defendants are presumed innocent, and this presumption remains with them unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that one or both of the defendants are guilty of one or more of the crimes charged. The state must prove every material allegation of the indictment and every element of each crime, and I'll tell you what those elements are soon, beyond a reasonable doubt. There is no burden of proof upon the defendants, and the burden never shifts to them. If a defense is raised by the evidence, the burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove either defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It's the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. And that reason arises from your evaluation of the evidence, lack of evidence, or conflict in the evidence. If, after considering the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if that doubt does not exist as to a defendant's guilt, you would be authorized to convict. Evidence that merely places upon a defendant grave suspicion of the crimes charged, or that merely raises a speculation about guilt, is not sufficient to convict. It is my responsibility to instruct you on the law. That's what's happening right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence that has been presented. You must then apply the law I'm giving you to the facts that you find to see if the state has met its burden. You must decide this case based only on the evidence presented during trial. That evidence consists of testimony and exhibits. Evidence does not include, as I've now said several times, the indictment or pleas of not guilty. It does not include anything that I've said or the lawyers have said or Mr. Pritchett, aka the accused. And that would include their opening and closing remarks. And finally, evidence is not the questions that were posed. And that means questions that lawyers may have asked or that you may have written down. And I mentioned this at the beginning, the fact that you wrote down a question and maybe I didn't pose it to the witness is evidence of nothing, because questions aren't evidence. It's only the answers to the questions. Now, this evidence that you've received may be direct or circumstantial or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I saw that the light was red when the car went through the intersection. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. The classic example, someone walks in here with an umbrella and they're soaking wet. We can't tell, because my courtroom doesn't have any windows to the outside, whether it's raining or not. But that would be circumstantial evidence that it's raining. It could be that a sprinkler broke on another floor in the building, and that's why the person happened to have an umbrella and they got wet. But it is circumstantial evidence that it was raining. There is no legal difference in the weight that you may give to direct or circumstantial evidence. And in considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of the witnesses. In deciding this, you may consider all the evidence you've received, the witness's manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, and their interest or lack of interest in the outcome of the case. You may also consider any possible motive in testifying, to include any pending prosecutions or grants of immunity. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here in court to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You all have heard from expert witnesses Those are people who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. Testimony of an expert, like that of all the other witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is generally not required, provided you find the witness's testimony to be sufficient. But there is an exception, and that's an accomplice. And an exception to this rule about no need for corroboration applies when the witness is an accomplice to the crimes charged. The testimony of an accomplice alone is not sufficient to warrant a conviction. The accomplice's testimony must be supported by other evidence that supports an inference of the defendant's guilt, independent of the accomplice's testimony. The supporting evidence does not on its own need to be sufficient to warrant conviction, nor does the accomplice's testimony need to be corroborated in every material way. The supporting evidence must be more than that a crime occurred. It must be sufficient to connect the defendants with the crimes and must do more than merely cast upon them a grave suspicion of guilt. Slight evidence from another source that connects the defendants with the commission of the alleged crimes and tends to show their participation in those crimes can be sufficient supporting evidence of an accomplice's testimony. In order to convict, that evidence, when considered with all the other evidence, must be sufficient to satisfy you, beyond a reasonable doubt, that the defendants are guilty. Whether any witness in this case was an accomplice is for you to determine. Immunity. Several witnesses were granted immunity for purposes of their testimony at this trial. This simply means that nothing they said while testifying to you can be used against them in any prosecution, other than for perjury. This type of immunity does not mean that the witnesses will not be or are not being prosecuted for the crimes alleged in this indictment or for other crimes. A defendant who has no burden to prove anything is not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. Sometimes evidence is admitted against one defendant and not the other, and I have identified those instances in this case. You may consider such evidence, if any, only as to the defendant against whom it was admitted. You have received evidence of a prior conviction of defendant Pritchett. You may consider this conviction only insofar as it may be evidence of one, that defendant's connection to a criminal street gang, and or the required element of being a first offender probationer for the offense in count 20, and not for any other purpose. Identification. The state must prove the identity of the persons who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for this purpose. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, that you head out in the street saying, I'm going to do something that's illegal. It means simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendants are not presumed to have acted with criminal intent, but you may find that intent or the absence of it from your consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendants are being prosecuted. You may not find a defendant who was merely present at the scene of a crime at the time it occurred guilty of the crime unless the evidence shows, beyond a reasonable doubt, that the defendant committed the crime, helped others to do so, or otherwise participated in the criminal activity. You also may not find a defendant who merely associated with other people involved in the commission of a crime guilty of that crime unless the evidence shows beyond a reasonable doubt that the defendant helped in the perpetration of the crime or otherwise participated in the criminal activity. We're more than halfway there. Conspiracy. A defendant engages in a conspiracy to commit a crime when he, together with one or more others, agrees to commit a crime and one or more members of the group does any act to bring about the object of the conspiracy. And a conspiracy is simply an agreement between two or more people to do an unlawful thing. The existence of a conspiracy may be proven by conduct as well as by proof of an express agreement. When people associate together in an unlawful enterprise, any act done by one co-conspirator to further the conspiracy is legally the act of all the conspirators. However, each person is responsible for the acts of others only insofar as those acts are done to further the conspiracy. You may consider presence, companionship, and conduct before and after the commission of the alleged crimes in determining the existence of a conspiracy. Every party to a crime may be charged with and convicted of a crime. A person is a party to a crime if that person, A, directly commits the crime, B, intentionally helps in the commission of the crime, or C, intentionally advises or encourages others to commit the crime. It is not relevant to your deliberations that other individuals who may have been involved in the planning or commission of the alleged crimes are not being prosecuted, or that only some of the defendants charged in this case are in trial. You are considering only the two defendants presently on trial. Venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Okay, we are now getting into the specific elements of the crimes that are charged in the indictment. In count one, home invasion is our first one. For home invasion, the state must prove that a defendant, number one, entered the residence of another person, two, without authority, three, with the intent to commit a forcible felony, a term which I will define, four, while in possession of a deadly weapon, and five, while that residence was occupied by someone with the authority to be there. Forcible felony includes armed robbery, aggravated assault, and aggravated battery. Speaking of armed robbery, for armed robbery, the state must prove four things. They must prove that a defendant, one, took another person's property, two, directly from the other person or from the immediate presence of the other person, three, by using an offensive weapon, and four, with the intent to commit theft. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if it is used against someone. Aggravated assault. A person commits an assault when he attempts to commit a violent injury to another. A person commits an aggravated assault when he assaults another with a deadly weapon. A firearm is a deadly weapon. Aggravated battery. Remember, we're down to one count of aggravated battery. For aggravated battery, the state must prove that a defendant, number one, maliciously caused bodily harm to another person. Two, by seriously disfiguring a part of that person's body. In deciding whether a defendant acted maliciously, please understand that malice in the context of aggravated battery is not ill will or hatred. You don't have to dislike the person that you committed an aggravated battery against. Malice in this context means simply the intent to cause the bodily harm without justification or excuse. It's not self-defense or anything like that. Malice also means willfully doing an act while aware of a strong likelihood that the harm may result. The defendants are charged with violating the Street Gang Terrorism and Prevention Act. One way a person violates the SGTPA is when he, while associated with a criminal street gang, excuse me, commits a crime that constitutes criminal gang activity. Criminal gang activity means the commission, attempted commission, or conspiracy to commit any criminal offense in the state of Georgia that involves violence, possession of a weapon, or use of a weapon. And here, home invasion, armed robbery, aggravated assault, and aggravated battery all constitute criminal gang activity. To prove a violation of the SGTPA as it is charged in count 18, the state must show four things. Number one, the existence of a criminal street gang. Two, that the defendant is associated with that criminal street gang. Three, that the defendant committed or participated in the alleged crime. And four, some nexus or connection between the crime that was committed and the gang. Criminal street gang means any group of three or more persons which engages in criminal gang activity. The existence of a criminal street gang may be established by evidence of a common name or common identifying signs, symbols, graffiti, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Two more offenses I need to define for you. One, possession of a firearm during commission of a felony. This is a profound definition. A person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. It's the only felony where the title of the felony defines the felony. Home invasion, armed robbery, aggravated assault, and aggravated battery are all felonies. And again, firearm includes any handgun. And finally, count 20, possession of a firearm by first offender probationer. A person commits the offense of possession of a firearm by a first offender probationer when he possesses a firearm while on probation for a felony as a first offender probationer. Yes, that name is also self-explanatory. Home invasion, armed robbery, aggravated assault, and aggravated battery are all felonies. And as before, firearm includes any handgun. All right, now some operating instructions for you all as jurors. In the jury room, you will have these two verdict forms, one for Mr. Robinson, one for Mr. Pritchett. You should consider each count in the indictment individually as to each defendant. All but one of them charge both defendants. Count 20 is Mr. Pritchett only, but you should consider each count individually as to each defendant. Each defendant may be separately found guilty of some, all, or none of the charges. If, after considering the evidence together with this charge, you should unanimously find beyond a reasonable doubt that one or both of the defendants did commit in Fulton County any of the crimes alleged in the indictment, you would be authorized to find that defendant guilty. And in that offense, the form of your verdict would be, we find defendant X guilty. And you would check that option on the verdict form for that offense for that defendant. And the verdict form simply lists each count that applies to that defendant. And for Mr. Pritchett's, which I'm holding, count 1, home invasion, it says we find defendant Pritchett, and there is a blank and a not guilty and a blank and guilty. If you unanimously find Mr. Pritchett not guilty of count 1, you check not guilty. Same for every other count for both defendants. If you do not believe that a defendant is guilty of a particular offense, or if you have any reasonable doubt as to that defendant's guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we find defendant X not guilty. And you would check that option on the verdict form for that offense for that defendant. Whatever your verdict is, it must, for a particular count, it must be unanimous. Your verdict must also be in writing, meaning on this form, signed by your foreperson and dated. Ladies and gentlemen, by no ruling or comment that I have made during trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of either defendant. I have referred to one of the defendants as the accused at his request. Your verdict must be based solely upon your consideration of the evidence, according to the laws that I am almost done giving you. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You are not to concern yourself with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign the verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, this should not surprise you, you must not communicate with anyone outside your group, nor may you conduct any research. You have all the evidence you're going to get in this case. It's enough, it's not enough, it's conflicting, it's not conflicting. You work through that. It would be improper to supplement it with any outside information. To help ensure that happens, Deputy Gordon will be collecting all your electronic devices, to include Apple Watches, please. We'll hold them back in my chambers. I promise you'll get them back when you are done for the day. But while you're in the jury room deliberating, it's you and the evidence and your collective recollection. Finally, going forward, should you need to communicate with me in any way, for any reason, it must be in a particular way. It must be in writing. You got to write it down. Write out your question, your concern, whatever it is. Deputy Gordon will collect that. He's going to show you, I think you've done it before, how to make that light go on. He brings it to me. I share it with all the parties, and then I will respond with whatever response I'm allowed by law to give. And I caveat that because you may have a great question and my answer might be, you know what? You're going to need to figure that out yourself. And you say, Judge, we wouldn't have asked you if that was going to be what you tell us. But there are times when I'm not authorized to give you what you're asking for. As an example, don't ask for the transcript of any witness testimony. You rely on your collective recollection of what witness X said. I will not be giving you a transcript of any witness testimony because it doesn't exist. That's it. I'm going to ask all of you but one to go back to the jury room, and very soon, Deputy Gordon will bring you the jury charge, the verdict forms, and the indictment, along with all the exhibits that are going back for your consideration. There were a couple exhibits that you heard me admit as demonstratives, a couple PowerPoints. Demonstrative aids don't go back with the jury. So if you're looking for that gang PowerPoint, you're not going to find it, because while that is in the record, that will go up on appeal. If there is an appeal, it's not part of the evidence that the jury will be considering, but all the photographs and texts and this and that, or the whatever we call the Instagrammy back and forth, that'll be with you for your deliberations. Any logistical questions? When you need a break, you should feel free to break. You may not deliberate with less than 12. If someone says, I need to walk down the hallway for a little bit because it's been a minute, that's fine, and let that person or those people do that. But you deliberate as a dozen and not as 8 while 4 people are doing something else. Breaks are fine. You control the schedule for the rest of the day. We have to kick you out of the courthouse by 7. But between now and 7, it's your schedule. You finish before then, you finish before then. You don't finish by then, we're going to get together tomorrow. But you break when you want, and if you need anything, light goes on, Deputy Gordon zooms in and gets you what you need. And again, if it's a question or something like that, it's in writing, and I will respond as I am able. So if all of you, except for, I can find my list, is Echolas, you stay put. It's good you're sitting in that last seat. It's like you had a crystal ball. The rest of you, back to the jury room, start detethering from your electronic devices, or send that last text saying, I'm going dark. And we'll get you the evidence shortly. You all can be seated. You are alternate. So what that means for the rest of today, at least, you're going to be in our other jury room. Deputy Gordon's going to show you where that is. There's a restroom in there. And I promise if we resolve the case today, we won't forget you. We'll bring you out. And we're gonna see what happens. If this group is coming back tomorrow, I know you cannot be here in the morning and you shouldn't be here in the morning. So we'll figure that part out. But for the rest of the day, I'm gonna ask you to stay here. The one exception is you can keep your electronic devices. So if you brought something to plan for commencement, whatever you got tomorrow, you may feel free to use it, but no outside research. I need you to stay limited to only the evidence that was presented during trial. If we lose one of those jurors, you join that group and they start over with their deliberations. You don't join them midway. They actually would restart everything they were doing and you would become juror number 12. We actually hope to have 14, so we'd have 2 alternates, but we had to release someone day 1. So any questions about that? Okay, if you have stuff back there, if you grab it, then Deputy Gordon will get you into that other jury room and we'll just get you out here when there's some update, okay? Thank you. Mr. Hiles, do you have anything you want to get on the record before we go off the record and then you and Ms. Mignot and Mr. Pritchett figure out what's going back with the jury?
No, Your Honor.
Okay, Ms. Mignot
No, Your Honor.
and Mr. Pritchett. Okay, my policy is that all the thumb drives and everything go back with the jury. They won't play them back there. They don't have a way to do it, but that's their way to be reminded, oh, there was this digital media. And if they want to figure out how to ask us to watch it again or look into it, they can do that. But we don't not give it to them just because they can't play it. So really the only thing that shouldn't go back that I'm remembering right off the bat would be obviously the 2 demonstratives. But if you 2 lawyers would start by going through there and then let me know what I need to mediate if there's a disagreement.
Oh, yeah.
This is out. This is demonstrative. This is okay, this is the actually this is 25.
We're going to different doors.
Oh.
It doesn't matter how many we always put.
I did, yeah, I got those every day. Like, it's 25. Okay, this is out.
Right, so you're 8. So
Like to see the stack below.
We got it.
Yes.
You already pulled it.
We can have this in order.
Yeah, we can, yeah, that's where it's easier.
Oh, you just came through there?
Yeah.
Okay. What's going on back there?
But
Right, Mr. Pritchett should stay out. He just needs to, if there's any concern about what's going on back to the jury, he needs to have a say in that. So it's fine for Mr. Robinson to go back. And Mr. Robinson, just so you know, the way this process will work, anytime the jury has a question or anything that I need to share with your lawyers, you'll be brought out for that. So they're not going to come out back there and say, hey, here's what we did. If there's anything that I need to get involved with, your lawyer will be a part of it, which means we'll bring you out here for that. Okay? Pardon? No. Just this, just to see what goes back. And then he'll, just like Mr. Robinson, he'll come out here when there's a question, but no. Only they're sorting out what goes out with the jury, and
Oh, it's two.
he needs to be heard on that as well.
33.
Oh, that's a good idea.
Thank you, Ms. Rivers. So we don't have to do it 6 times?
Yes.
Good point. Trevor's always keeping us in check.
I'm gonna miss I wrote it out.
I think it's, they did this just minutes.
If it's in there in 28.
Right now. Oh, this is the 8.
Yeah.
Yes, Gina.
Yes. C is.
That's the conversation with everything on.
Oops.
From Lawrence. considering conversation.
Lyndsey and Warren. $29. It started at 10.
That was when they're probably the records.
Yeah.
That was in through Sloss. There are two in there.
I'm sorry.
Yeah.
Yeah.
Yes.
34 is in, but it's going back, it's not going, separated, it's not.
6 is Robinson extraction.
So let's, here are the ones that keep kept separate as.
I just want to know what's going. You guys do what you want. Leave
We're
it.
done with what's going.
Okay.
Not yet, not
We
yet,
got
not
the-
yet, not yet, the defense.
Mr. House, you have a 34 and 38 over here, the demonstrative.
Yeah,
And these are the ones. Yeah, they're going back to the ones. So we can let's put it in here.
So 17. These,
12 is not wrong yet.
that's for the record. 22 is for the record, that was. 5B is my understanding, was for the
Not wrong
record.
that yet.
And,
5 not wrong. 5 again.
so all I had
But 1 through 4.
Yes.
was.
Those are the interviews with Kallish.
So 1 through 4 are interviews. I don't remember the interviews being admitted. I'm not saying we can't do it now. They don't have to be.
I think Mr. Abadi stipulated to him.
Oh, that's right. That's right. He did, so that we weren't going to necessarily, yeah. So that way, you could ask either Kallish or Riley. Yes, they're in. So 1 through 4 and their subsets are all in.
So we're good, Judge. We have all the evidence.
Okay. Well, let's get on the record, Ms. Rivers, real briefly. We are back on the record in State versus Robinson and Pritchett. Mr. Hiles, do you agree that what is in that illegally retained United States Postal Service bin constitutes the evidence that ought to go back with the jury?
Does that make me an accomplice? Yes, I do agree.
All right, Ms. Mignot
I agree, Your Honor.
and Mr. Pritchett.
No, I'm not an accomplice either.
You're not an accomplice either. We'll tape over that. I'm handing to Deputy Gordon 2 verdict forms, the indictment and the jury charge, and the jurors are underway. If I could have a, Mr. Howes, if you would write on here, and then Ms. Mignot, 1 phone number that will get you and Ms. Blake back here. We'll get you back out here, Mr. Pritchett, anytime there is any court activity. Be in recess till then.
Oh,
All right,
She went to the back of the
okay.
That's taking enough time.
All right, Ms. Rivers, are you ready? Okay, we are back on the record in State versus Pritchett and Robinson. The jurors had 3 questions. One is there a police report from the incident? Second is, can we have an exhibit list? And the third says, count 4. Noah Walker testified that his wallet was stolen, but the indictment says his cell phone. Does it matter what item was stolen? The indictment does not match what the witness said. Question 1, is there a police report from the incident? Question 2, can we have an exhibit list? Question 3, about how the allegations in count 4 don't match up in the jurors' minds with the testimony from the alleged victim, Mr. Walker. I propose answering question 1 with language to the effect, and I'll write it on the back of the card and read it into the record. There may well be, but it is not in evidence, period. Any issue with something like that, Mr. Hiles?
No issue.
Ms. Mignot?
No issue.
Mr. Pritchett?
No, so you're saying it can't be entered into evidence?
Correct. We can't add anything more. The exhibit list, that won't be evidence. It may be that we get them an exhibit list, but if something wasn't tendered, and actually in the record is a police report, but it's not in the type of evidence that the jurors could get. Jurors very, very rarely get things like police reports because they are close to being continuing witness situations. So I'll write something to that effect, read it into the record. Mr. Hiles, I don't mind getting them if you have a clean. I wrote all over your exhibit list, and we have one from Ms. Mignot that I didn't write on, but not everything was admitted, and I don't want to send them an exhibit list that has items that weren't admitted for their consideration. So I'm inclined to say you have all the exhibits.
Yes, that's what my inclination, because the exhibit list I created, there was, the way the trial went, I didn't put everything in. And I don't want to I think it's improper to bring to their attention other potential evidence.
Right. I mean, we could invest some time in editing your exhibit list to remove things that were not admitted, but we'd need to add you beyond the printed list that you got to the other side and to me, you added a few more. And then Ms. Mignot's is good to go. It just we need to remove stuff that wasn't admitted. And then there's that added complication of 1 through 4 were admitted for the record, but they're not going back there. I'm inclined to say you have all the exhibits. There's not a list of all of them. I'll word it better than that. You have any objection to that?
I don't.
Ms. Mignot?
I would agree with that. I would object to them getting some type of list, like
Okay.
the evidence.
Right. Okay. It's not like there are 1,000 exhibits in this one. So I think they can organize it. Last trial, I might have said, okay. Mr. Pritchett, do you have any objection to me saying, in effect, you don't get an exhibit list? Okay. Question 3. What do you say, Mr. Hiles? I don't have an indictment anymore. I had the, I can get it up on the screen here. If I want, I share it so we're all looking at the same thing. Indictment. All right, on the screen is the indictment, and in particular, count 4, which charges the defendants with the armed robbery of Noah Walker. And the allegation is that his cell phone was taken. And the jurors are saying, he testified that his wallet was taken and not his cell phone. I think the correct answer is, if the state hasn't proven that his cell phone was taken, then I'll word it differently, then the state hasn't proven that count, because it doesn't say anything about a wallet. And this isn't one where, hey, you misspelled Buckingham's name or left out part of his name. The allegation is cell phone, and that's not, they think, what Mr. Walker testified to. I remember one of the witnesses saying X was taken, and I looked at the indictment and said, that's not what the indictment says. And at least one of them said X and Y were taken, and the indictment said X, Y, and Z. That latter situation is not a problem, because one or more of the items alleged, the victim said, no, that was taken from me at gunpoint. But one of them, and I'm guessing the jurors are right, that is Walker, that's why they take notes. Walker said they took X, and the indictment said Y is what was taken. So enough talking from me. Your thoughts?
I'm trying. He definitely says wallet, but
It's not our job to say you're not remembering correctly. I need to respond to their question. Okay.
Yes.
I'm going to write something, I think, to the effect of, if the state didn't prove what was alleged in the indictment, the state didn't prove the armed robbery. I can say if the indictment says X and they didn't prove X, then they didn't meet their burden. I think that's the legally correct answer. And then I'm not saying, are you sure that's what Walker said? Because I don't remember. Ms. Mignot, your thoughts about question 3?
I agree, Judge. I agree with the court's assessment a few seconds ago, that telling them exactly what you just worded.
Okay, I'll wordsmith something. Mr. Pritchett, you adopt Ms. Mignot's response, or you have a different one? Okay. Yes, you adopt?
Yes.
Okay, all right. Let me craft some language and read it back into the record.
You said that they were paying attention.
Someone was. So question 1, is there a police report from the incident? Response, there are no police reports in the evidence you may consider. Any issue with that, Mr. Hiles?
No, Your Honor.
Ms. Mignot?
No, Your Honor.
Mr. Pritchett? Question 2, can we have an exhibits list? Response, you have all the exhibits. There is not an exhibit list. I hate writing that, but that's the answer. Mr. Hiles? No issue? Ms. Mignot?
No issue, Your Honor.
Mr. Pritchett?
No, but for the first one, you can't tell them that there is a report, but that there is none in the evidence that they can.
That's what I said. There are no police reports in the evidence you may consider. They know they're police reports. You were holding them up, other people, they want them. Jurors always want the police reports. That's okay. Last question. It says count 4. Noah Walker testified that his wallet was stolen, but the indictment says his cell phone. Does it matter what item was stolen? The indictment does not match what the witness said. Answer. If the state alleged in the indictment that a specific item was taken, and you find that the evidence does not support that allegation, then the state has not met its burden. Mr. Hiles, any issue with that?
No issue. Well, I think some counts, like my only issue concern would be that, like you said, in other counts, there were some that listed 2
Or 3?
or 3.
We may have a follow-up question, and I'll need to deal with that. I agree with you. I couldn't come up with a different way.
Okay, yeah, that's, other than that, I have no objection.
Okay, I share your concern because this other count, if they are being that careful, and it's great that they are, and so they'll get to Gattani, wallet and cell phone. And if he said, I think he actually said both those, but if he said one, we got Riggs, it's laptop, keys, and wallet. And maybe he said my keys and my laptop. They can ask, it's a different situation. But I think this addresses that situation.
I concur.
Ms. Mignot, any objection to that language?
No, Your Honor.
Okay. Mr. Pritchett, I feel like I'm interrupting you as you read the good word and we're working through this. Any objection to that answer? Okay. I'll have Deputy Gordon return those questions to the jurors. We'll make these part of the record once deliberations are complete. Hang loose, and I'll come back out when there's more. All right. After, just in case someone, always safe space. And then when we're doing the whole thank you, whatever, then she can come out.
Oh my goodness.
Yeah.
That was
Correct.
one that, you know.
Right. No, but it's all the same. Gotta work on when they gotta work on it's very much longer.
All right, well, let's get on the record. It's late and we've got jurors who've been here all day. We're back with State of Georgia versus Robinson and Pritchett. Deputy Gordon tells me that the jurors have reached a verdict as to both defendants. Ms. Mignot, is there anything that we need to talk about before we bring the jurors out?
No, Your Honor.
Okay, Mr. Pritchett, anything we need to talk about before we bring the jurors out? All right, let's bring the jurors out.
All right, for jurors.
That's the right count. All right, you all can be seated. Could the foreperson please stand? You're the foreperson. Have you and your colleagues on the jury reached a verdict as to defendant Pritchett?
Yeah.
Have you also reached a verdict as to defendant Robinson? And is it a unanimous verdict?
Yes.
Did you sign and fill out the verdict form on behalf of your colleagues?
Yes.
All right, if you would hand the verdict forms to Deputy Gordon, we'll hand them to me. Gordon, if you return them to the foreperson. I will ask you now to publish the verdict, which simply means read in the verdict as to each count, starting with either defendant, but make clear for the record which defendant you are providing the verdict for, and we'll go from there.
Okay, for Tyrone Robinson. Count 1, home invasion, we find defendant Robinson guilty. Count 2, armed robbery, Carmody, we find defendant Robinson guilty. Count 3, armed robbery, Hooper, we find defendant Robinson guilty. Count 4, armed robbery, Walker, we find defendant Robinson not guilty. Count 5, armed robbery, Mears, we find defendant Robinson not guilty. Count 6, armed robbery, Buckingham, we find defendant Robinson guilty. Count 7, armed robbery, Gattani, we find defendant Robinson guilty. Count 8, armed robbery, Riggs, we find defendant Robinson not guilty. Count 9, aggravated assault, Carmody, we find defendant Robinson guilty. Count 10, aggravated assault, Walker, we find defendant Robinson guilty. Count 11, aggravated assault, Mears, we find defendant Robinson guilty. Count 12, aggravated assault, Buckingham, we find defendant Robinson guilty. Count 13, aggravated assault, Gattani, we find defendant Robinson guilty. Count 14, aggravated assault, Riggs, we find defendant Robinson guilty. Count 15, aggravated assault, Hooper, we find defendant Robinson guilty. Count 16, aggravated battery, Gattani, we find defendant Robinson guilty. Count 18, participation in criminal street gang activity, we find defendant Robinson guilty. Count 19, possession of firearm during commission of felony, we find defendant Robinson guilty.
Thank you, sir. And if you would turn to the verdict for defendant Pritchett.
Count 1, home invasion, we find defendant Pritchett guilty. Count 2, armed robbery, Carmody, we find defendant Pritchett guilty. Count 3, armed robbery, Hooper, we find defendant Pritchett guilty. Count 4, armed robbery, Walker, we find defendant Pritchett not guilty. Count 5, armed robbery, Mears, we find defendant Pritchett not guilty. Count 6, armed robbery, Buckingham, we find defendant Pritchett guilty. Count 7, armed robbery, Gattani, we find defendant Pritchett guilty. Count 8, armed robbery, Riggs, we find defendant Pritchett not guilty. Count 9, aggravated assault, Carmody, we find defendant Pritchett guilty. Count 10, aggravated assault, Walker, we find defendant Pritchett guilty. Count 11, aggravated assault, Mears, we find defendant Pritchett guilty. Count 12, aggravated assault, Buckingham, we find defendant Pritchett guilty. Count 13, aggravated assault, Gattani, we find defendant Pritchett guilty. Count 14, aggravated assault, Riggs, we find defendant Pritchett guilty. Count 15, aggravated assault, Hooper, we find defendant Pritchett guilty. Count 16, aggravated battery, Gattani, we find defendant Pritchett guilty. Count 18, participation in criminal street gang activity, we find defendant Pritchett guilty. Count 19, possession of firearm during commission of felony, we find defendant Pritchett guilty. Count 20, possession of firearm by first offender probationer, we find defendant Pritchett guilty.
Thank you, sir. Deputy Gordon, if you would please share that verdict form with Mr. Hiles, Ms. Mignot, and Mr. Pritchett. Mr. Hiles, do you have any objection to the form of the verdict
Yeah, Your Honor.
as to either defendant?
Yeah, Your Honor.
Ms. Mignot, I can't tell if you're still looking at the verdict form. Did you get a chance to look at it? Okay,
With Mr. Pritchett.
got it. Do you have any objection to the form of the verdict?
No, Your Honor.
Mr. Pritchett, do you have any objection to the form of your verdict? Okay. Mr. Hiles, anything else before I excuse the jury?
Not from the state.
Ms. Mignot?
We'd like the jurors poll.
Okay. Ladies and gentlemen, polling of the jury is simply, I'm going to call each of you one by one. I'll just use your last name and ask you the same 3 questions. And so when I do call your name, if you would stand, I'll ask you the 3 questions. We'll see what your answers are, and we'll work through it that way. Juror number 1 is Watson. Oh, that's who we excused. Like, that was gonna be awkward. Long gone. I'm like, I don't remember interacting with her. How about juror 2, Shane? All right, bumpy start here, not your fault, because Watson didn't stand up. Was the verdict you just heard in court your verdict in the jury room as to both Robinson and Pritchett?
Yes,
And was it freely and voluntarily entered into?
yes,
Is it still your verdict?
yes.
Thank you. Next is Ms. Anderson. Ms. Anderson, was the verdict you heard here as to Pritchett and Robinson your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into those verdicts? Do they remain your verdicts? Thank you. Juror 4, Taylor. Sir, were the verdicts you read in court your verdicts in the jury room?
Yes.
Did you freely and voluntarily enter into them? Are they still your verdicts? Thank you. Juror 5, Ms. Martin. Were the verdicts read here in court your verdicts in the jury room?
Yes.
Did you freely and voluntarily enter into those?
Yes.
Are they still your verdicts? Thank you. Juror 6, Ms. Freed. Were the verdicts read here in court your verdicts in the jury room? Did you freely and voluntarily enter into those? Do they remain your verdicts? Thank you. Mr. Frank. Were the verdicts read in court your verdicts in the jury room?
Yes,
Did you freely and voluntarily enter into them?
yes,
Do they remain your verdicts?
yes,
Thank you. Juror Stanley. Were the verdicts read here in open court your verdicts in the jury room? Did you freely and voluntarily enter into them? Are they still your verdicts? Thank you. Juror Lynch. Were the verdicts read here in court your verdicts in the jury room?
Yes.
Did you freely and voluntarily enter into them?
Yes.
Do they remain your verdicts?
Yes.
Thank you. Juror Johnston. Were the verdicts read in court your verdicts in the jury room?
yes,
And are those things you freely and voluntarily joined?
yes,
Do they remain your verdicts?
yes,
Thank you. Juror Karras. Were the verdicts read in court your verdicts in the jury room?
Yes.
Did you freely and voluntarily enter into them?
Yes.
Are they still your verdicts? Juror Hinner. Were the verdicts read in court your verdicts in the jury room?
Yes.
And did you freely and voluntarily enter into them?
Yes.
Are they still your verdicts?
Yes.
Thank you. Juror Goodwin. Were the verdicts read in court your verdicts in the jury room?
yes,
Did you freely and voluntarily enter into them?
yes.
Do they remain your verdicts? Ms. Mignot, anything else from the jury before I excuse them?
Not from the jury, Your Honor.
Okay. Mr. Pritchett, anything else before I excuse the jury? All right. Ladies and gentlemen, on behalf of the state, Mr. Robinson and his legal team, and the accused, I want to thank you for your time, many days you spent working through this important situation, important to the many victims in this case, important to Mr. Robinson, important to Mr. Pritchett. This case has been around for a while and it required a jury to resolve it, and that was you 12. So thank you for your time. I'm gonna have you go back to the jury room. You'll be reunited with your electronic devices and your alternate. I need to come by and say a couple things, and then you'll be able at long last to be on your way, not having to come back here anytime soon. Okay, thank you. I'll see you in a second.
All right, adjourned.
Sentencing will be Thursday at 2. we will bring Mr. Pritchett and Mr. Robinson back. Ms. Mignot, I normally don't impose dates on you, knowing your schedule, but my understanding was that this week had been cleared for this trial. We found the window of, I don't want sentencing to linger out there. It's too late to do it tonight. Thursday at 2 was a window that worked. Can you make that work?
We should be able to, Judge.
Okay, excellent. All right, thank you, everyone.
Before we come off the record, Your Honor.
We're still on the record. Yes, ma'am.
We would move for judgment notwithstanding the verdict at this time.
Okay, I will take that under advisement.
Thank you, Your Honor.
Anything from you, Mr. Hiles?
No, Your Honor.
Mr. Pritchett? All right, thank you, everyone.